Please rise. The Justice of the Appellate Division, Supreme Court, first of all, being here, your first matter of business in the Appellate Division, going here, the attendance, you shall be heard. Please be seated.
Good afternoon and welcome to the Appellate Division First Department. And I want to start by welcoming the Dare to Dream scholars from Big League School in the Bronx, the Shirley Rimaniski Charter School. Ladies, welcome. We are so happy to have you here. And they are aspiring lawyers in the making, so we hope that nothing they see here today discourages them from that pursuit. All right, guys, you know the drill. I'm going to go through the calendar. Please give me the time that you need, not the time that you want, understanding that the court is familiar with the case, the record, your briefs, and know that we have 5 hours of requested argument time. So you make the cut, so I don't have to. And as I say, if you are brilliant and my colleagues have additional questions, the clock is for you, not for them, okay? All right. People versus Devin Webert. 5 and 1 and 5. Stuyvesant Town versus New York State Division of Housing and Renewal. Okay. All right. 4 and 2, 4 and 2 and 6. Damina versus Bodin J. Okay. 5 and 2 and 6. Weatherspoon versus Mazal. Ubracha. Okay. Okay. 5 and 1 and 5. Everyone's being reasonable today. This is good. People versus Hector Hernandez. Okay. 5 and 2 and 5. Board of Managers versus Miller. Okay, well, you're here alone, so do you need 6?
I'm not sure if he's showing up.
Well, no, if he's not here to ask for argument time, he's out of luck.
Then I need 5.
Oh, you need 3. Okay. Daniello versus JT Megan and Company.
Howard, 5 and 1.
Okay.
Respondent 4, Your Honor.
Yes. 5 and 1, 4 and 4. People versus Sergio Ceri.
6 and 2, Your Honor.
Okay. All right, I'm gonna do 5 and 2 and 5. People versus Damian Bell. Okay. 5 and 1 and 5. One Riverrun versus Mild.
Request 5 and 1, Your Honor.
Okay. 5 and 1 and 5. Olympic Galleria Company versus SIT.
Appellant, request 4 and 4. Respondent cross appellant, request 4 and 2, Your Honor.
Okay, 4 and 4, 4 and 2. People versus Adam Rivera. Submit. Rosario versus Halen Construction. Submit. Prospect Capital versus Morgan Lewis. Submit. First case on the calendar, People versus Devin Webert. No, it's not on the. You may proceed.
Good afternoon, Your Honors, and may it please the Court, Nusayba Hamad for Mr. Devin Webert. This Court should reduce Mr. Webert's sentence to reflect that this was a tragic set of circumstances, but one that does not represent the life that Mr. Webert has led.
Did we even get to that issue without first addressing the waiver of the right to appeal?
Yes, Your Honor. The purported waiver here was invalid for 2 main reasons. The first being that the court's explanation of the waiver was overbroad. It incorrectly told Mr. Webert that he was giving up the right to appeal any legal issues in his case, plea, or sentence. And first of all, Mr. Webert could not waive the right to challenge the legality of his second sentence. And second, as the court explained it below, this purported waiver would not even cover excessive sentence because, of course, that is not a legal
So
issue.
the court said, as a separate and distinct condition of this plea, you're being required to waive your right to appeal. That means you ordinarily keep your right to go to a higher court than myself with any legal issues connected with your case, your plea, or your sentence. Do you understand that? And he said yes. Court went on to talk about the appellate division, the fact of separate conditions in terms of his rights. Court then went on to the written waiver of his right to appeal, stating you're not giving up constitutional issues which you could still appeal, the voluntariness of this plea, etc. So
Right.
what was wrong with that?
So the first thing that was wrong is that describing the waiver as covering any legal issues was overbroad. And
But then the court went on to explain what it meant by that, talking about constitutional rights.
it still did not correct the fundamental mistake here. And in addition to it, while the court used the words separate and distinct, it did not use those words in the right way. The way that the court explained,
What would have been the right way?
the right way would have been to explain to Mr. Webert that the right to appeal is not one of the ones that are automatically forfeited.
Our
upon pleading guilty.
jurisprudence has said repeatedly that there is no particular colloquy or litany that is required of the court so long as the totality of the circumstances and the plea and the allocution are sufficient to put the defendant on notice of what rights he's giving up. Seems to me that that was covered here.
The totality here, Your Honor, was not sufficient, especially for a defendant like Mr. Webert, where this was his first felony plea. And when he asked the court for clarification, the court doubled down on its mistake and repeated that the waiver covered, quote, any legal issues, and still failed to make clear that the right to appeal was not automatically forfeited. The concept that had to be conveyed to Mr. Webert is that the right to appeal is separate and distinct from the trial rights that are automatically forfeited, and that was not adequately conveyed here.
And the written waiver doesn't together?
No, Your
Don't we have case law that says that we can combine both the oral colloquy and the written waiver, and that, again, the totality of it is what the court needs to consider and determine?
The written waiver, Your Honor, cannot cure a colloquy as deficient as this one.
This is not, I've seen a lot worse. Okay, so would you like to address the issue of excessiveness of sentence?
Yes, Your Honor. We're asking the court to look at this within the light of Mr. Webert's life as a whole. He's worked steadily to support his family since his early 20s. He dropped out of high school to support his mother who had
Shot
cancer.
this man 7 times, at least.
At least. And then when the deceased turned to run, he shot him in the back.
Your Honor,
And I recognize that this is the one where he's talking about being jumped, right? Right. But again, at that point in time, there's no longer any type of aggression or violence towards him. There never was from the deceased, because the deceased never had a weapon, right?
that's not clear from the record below, Your Honor. What was absolutely uncontroverted below was that Mr. Webert was attacked by a very large group of people, up to 20 people is in the record below. And Mr. Webert
And the
understands
record based on your client's statement of that.
that was not controverted by the prosecution below. And Mr. Webert understands that he took a life, and that is very serious. He takes responsibility for that. And I think what is important to
What was
understand,
his exposure here?
his exposure, if he went to trial, was 25 to life.
Okay, and he got 10 off of that.
You got a flat 15, right?
Correct, but even a negotiated plea can be excessive, and it is within this court's jurisdiction to review that.
Well, again, given the fact that he shot the deceased multiple times, and you know, for me, to shoot someone in the back, I mean, the guy has turned and he's running away, and he shoots him in the back. And he was facing 25 to life. He received a flat 15 plus 5 years post-release supervision. He was 35 years of age at the time. So I know, you talk about research where the brain is not formed until 25, 26. He's 35 years of age. So I don't think there's any issue that the brain had already formed, right?
Correct, there's no neuro issue here. It is more that Mr. Webert did not set out his night intending anyone any harm, and that
Well, he did have a weapon. I mean, he was carrying, it was an illegal firearm.
that is also not clear from.
Oh, he had a license?
It's not clear where the gun came from, Your Honor. It's
Well, we know where the gun went because we know the shots went into the deceased, right?
correct.
You'll have time on rebuttal.
Thank you.
Good afternoon, Your Honors. Andrew Loizides appearing for the respondent of the people, and may it please the court. Your Honors, the defendant validly waived his right to appeal. He knowingly, voluntarily, and intelligently waived the right to appeal. And his
Counsel, what about your adversary's argument that in terms of indicating what was separate and distinct was not really that the defendant was waiving rights which were separate and distinct, but that the condition was separate and distinct?
Well, Your Honors, the lower court made sure to separate what it was that he was waiving from what was that would be allowed to continue on to appeal. And repeatedly, the court judge said, "Do you understand everything I'm telling you?" And repeatedly on the record, the defendant kept saying, "Yes, I understand. Yes, I understand." Did your attorney explain everything to you as well? Yes, my attorney did. Did you understand? Yes. Did you look over the written waiver of the right to appeal? Yes. Did you understand that? Yes.
And this is one of those cases, rarely actually, where the waiver gets signed after the colloquy.
Yes. Yes, Your
And
Honor.
after the waiver discussion, right?
That's correct, Your Honor. Yes,
Okay.
yes. So the defendant definitely knowingly, voluntarily, and intelligently waived his right to appeal. And as for his sentence, considering that he shot and killed a person and could have gotten 25 years to life imprisonment had he gone to trial and been convicted, took frankly, a generous plea deal where he received 15 years imprisonment, and any mitigating factors that defendant and actually defense counsel cites to was already present before the sentencing court when the defendant pled guilty. There is no basis for a reduction in sentence, Your Honors. And unless Your Honors have any further questions, I respectfully submit the rest of my argument on my brief.
Thank you so much.
Thank you.
Counsel, you have a minute on rebuttal.
So I do want to just clarify, because I do believe there's a misimpression about what happened below, and without minimizing at all that a life was taken here. It is important to understand that this was a situation of complete chaos, and there is nothing in the record below to support the fact that the victim was shot in the back. In fact, the sites in the record that my opponent presented were ones that stated that the victim was shot in the chest. And
It also said the torso, and the torso has a front and a back, so.
correct. And it is, again, I want to reiterate that Mr. Webert knows that he should not have reacted the way that he did that night. He should have gone home, whatever the situation was, and that there is nothing that will bring the victim back. And we are just asking the court to understand that he did not set out that night intending anyone any harm, and he will live with this for the rest of his life. And given the equities in this case and the invalid appeal waiver, that his sentence should be reduced.
Thank you so much. Matter of Stuyvesant Town, Peter Cooper Village Tenants Association versus New York State Division of Housing Community Renewal. Okay. Who will argue first? DHCR landlord. Okay, DHCR. You may proceed.
Good afternoon, Your Honors. The case that stands before you today involves an MCI application for the largest complex in all of New York City. The backdrop on the case is, of course, the rational or irrational, arbitrary or capricious standard. In this case, the tenants complained about several of the items, several issues. There were maybe 7 issues.
So you've got 4 minutes. Let's try to streamline this.
Okay.
There were 19 applications for MCIs, and the court disallowed all of them.
They disallowed 7 of them as untimely.
Right.
And they remanded to DHCR back to look at the issue of depreciability.
Demanding 12 of them, right?
12, the remaining 12, yes.
Okay.
So vacated outright the 7 that were untimely. And we believe that that was a reversible error. We believe that
So the court stated that you found that you relied on an as necessary standard as opposed to a comprehensive, and you did not do a comprehensive investigation or report as to what was going on.
no, we always looked.
I'm saying this is what the court said.
Yes, that's what the court said.
And
Correct,
so why was the court wrong? Why was the court incorrect in that statement?
The court was citing to our regs where we state that in order to qualify for this type of MCI, waterproofing and pointing, it must be a comprehensive, and so you must attack it as a comprehensive plan. You cannot have a tenant complain about a leak and then just go spot point where it looks like something is wrong. That would constitute a repair. A plan is an organized attempt to look at all the buildings up close with a professional pursuant to local law 11 and repair anything that needs to be repaired pursuant to wear or to shore
So
up.
one of the things that struck me is that the court talked about the fact that it wasn't comprehensive because the facade work was as little as 150 square feet of facade work was performed on some of the 15-story buildings with facades comprising approximately 1 million square feet. So what about that?
Well, Your Honor, first of all, if you look closely at the record, there is nowhere where that 1 million square feet comes up with. There's no cite to it. It was just told to the judge by the tenants, and he picked it up. He just used that. If you look closely through the record, you will see that there was copious documentation, and we only put a representative return in. There's literally a room full of returns. If you look at the record, there's a room full of them because there are 18 separate buildings.
With respect to pointing work, am I correct that currently, in order for DHCR to determine that there has been a comprehensive work done, that the landlord had to have their contractor inspect all of the exposed facade
Correct.
in order to determine where along the circumference of the exposed facade needs pointing work,
Correct, Your Honor.
and that is sufficient to satisfy the statute.
Correct, Your Honor.
Because to find otherwise would basically say, you landlord have to wait until a lot of the building needs pointing. You've got leaks all over the place before you can go in and fix.
That's 100% correct,
And
Your
that
Honor.
would be contrary to the entire purpose of the statutory regulation, to try to keep buildings in proper order and so that they are habitable by their tenants.
Yes, that is absolutely correct, Your Honor.
Thank you.
And in fact, we've been upheld by the Appellate Division with what they characterize as small pointing and being done, or certain portions not being done. We have been upheld by this court and other courts.
I searched high and low to find a case that had any kind of minimum de minimis square footage for this analysis, and I could find none. Is there any?
Your Honor, yes. I mean,
About 150
Oh,
square
not by
feet?
square
Yeah.
feet. No, not by square feet. And in fact, that's kind of, first of all, we do not know that those numbers are correct. But even if it's 10% or 5% of the facade, it would be ludicrous to have a building as well appointed as these buildings are. If everyone's passed by Styver's in town, they are well
You know what?
maintained
That
buildings.
doesn't matter. In my
Yeah.
mind, it doesn't matter whether it's Stuyvesant Town or 103rd Street. It doesn't matter. The point is that these regulations are in place for a purpose,
Correct.
and they have been interpreted the same way with respect to this issue
Yes,
for years.
yes, and
You'll have
upheld.
time on rebuttal.
Okay, thank you.
Okay. You may proceed.
Yes, good afternoon, Your Honors. Magda Cruz of Belkin Burden Goldman for the appellant owner. I would like just to pick up on 2 points. On the comprehensiveness issue, which goes to whether the depreciability element had to have been specifically determined by the agency. That is what the Supreme Court said, and we submit a completely new standard to require the agency to establish some kind of a rubric for deciding.
I mean, Supreme Court's decision would require an entirely new rubric.
Yes, I submit that that's the case. There's nothing in the statute that says that the agency has to outline the reasons why this project is depreciable. And in our brief, we maintain that once the finding of a qualified MCI has been made by the agency in which it finds that all the other elements of the MCI have been satisfied, such as useful life, that it's in the schedule, in the code, that it is a comprehensive project, that it inures to the benefit of all the tenants in the building, either directly or indirectly. Once those elements are met, it is then also a depreciable project, because the Internal Revenue Code states that a capital improvement is depreciable if it is not a repair, if it is something to prolong the life of the property, that it is to prevent deterioration, and that it is part of a comprehensive plan. And of course, our project overwhelmingly meets all of those criteria. I see my time is almost up, so I do want to touch on the timeliness issue, the 2-year statute of limitations that the lower court said that we did not meet. And we submit we absolutely did, because of the 7 applications that the court said were untimely. In those instances, we had a contract that covered a group of buildings. Yes, it is correct that the buildings were completed at different points, and then our MCI application may have been filed a few weeks, literally a few weeks after the 2-year mark. But the contract that covered that work was not satisfied, meaning fully paid and completely all the change orders in and completed until, for the most part, all of them were July 2013. And all of our applications were filed within 2 years of that point. And for that reason, we think that the lower court did not properly look at the completion of our project. It is not physical completion. The court had legal authority, and we submit the case law as well as DHCR decisions that indicate when you are involved in a multi-building project, you look at the completion of the contract. That's not the case in all instances, but is it irrational to have evaluated these applications in that manner? I submit no. There's no irrationality in this particular MCI order, the group of them, and we ask that the court reverse the Supreme Court in that it substituted its judgment for that of the agencies.
Thank you.
Thank you.
Good afternoon, Your Honors.
Good afternoon.
May it please the court. Let me just, first of all, respond to some of the questions that were raised. With regard to the comprehensive nature of the work, I think Your Honor pointed out that, that there was only a small fraction of the 1 million square feet. Actually, that was referenced in the opinion, but it was 50,000 square feet per building. The about 1 million square feet for the whole 19 buildings
So where
combined.
did that come from?
It's still, well, the 50,000.
Where did the numbers come from?
The $1 million, the million is.
Is it in the papers?
Yes, I believe it is the 50,000. It was a tenant statement. I don't recall exactly.
That's what I meant. You're stating it was a tenant statement. So was there any type of expert? Was there any
You know,
type
Your
of
Honor, the only thing I
measurement?
can do, Your Honor, is I actually calculated the footprint myself, and it comes out to approximately 50,000, which
And your
times-
expertise in doing so is what?
The court found correctly that it was less than 1% for several of the buildings.
Okay, so are there any regs, case law, or anything that talks about a specific quantitative
Well,
measurement?
that's an important issue here.
That's why I asked the question.
Yeah, let me, if I can, and I'm going to get right to that.
Appreciate it.
With regard to and I think a very appropriate question about should there be a disincentive for owners to do, a piecemeal work when it's required to replace the building. Local law 11 requires this stuff to be done every 5 years. It's a constant cycle. It's done all the time. And the question is whether or not it's sufficiently comprehensive to meet the depreciability standard established by the IRS. The state, the rent stabilization law, 26511C6, says that there must be a finding of depreciability. And depreciability is a federal standard. DHCR does not get to define what depreciability is. And with respect to the case that was, well, the request for a case which addressed this issue of depreciability and piecemeal work or spot work, there was a case. In fact, it's discussed at pages 29 through 35.
Can you give me the name of the case
Yeah,
instead
it's,
of giving me numbers of pages to go
Yeah,
look for it?
I'll just cite it here. Hold on one second. I'll give you the exact site.
We pulled every single case in your brief, and none of them, not one of them,
Your Honor, it's
not one of them had what I am looking for.
Your Honor, it's the matter of the administrative appeal of 201 East 19th Street. The matter was sent back by Justice Sachs to look at the issue of whether or
Can
not.
I get the citation?
It was in Article 78 that was sent back.
Counsel, citation.
Yeah, I'm
You
sorry,
know
Judge.
what that is.
So wait, you're stating that this was in your brief? That
Yeah,
case was-
yeah, the DHCR decision, and in response, DHCR sought clarification from the Internal Revenue Service.
Okay, I need you to stop because I've asked you for a citation. I just told you, I pulled every single case in your brief, and nowhere did I see any case.
The citation is to a DHCR decision, Your Honor, not to Justice Sachs. It must be cited in the DHCR decision that Justice Sachs.
Oh, it must be. You're not sure.
Well, it was sent back. The Internal Revenue Service issued an opinion specifically in response to the inquiry from DHCR in 1991 and extensively explained the criteria for determining what is depreciable.
The IRS, there is an IRS opinion stating that if replacement, repair, or renovation acts to retard deterioration and prolong the life of a property, then such expense should be capitalized and depreciated due to an increase in value or extension of useful life, and identifying examples such as complete waterproofing or brick walls or roof,
Right.
rather than just
and
the
at the end-
specific repairs of a leak.
That is correct. And at the end, it says,
So I don't read that in your favor.
I'm just,
What I just read does not support your position. It supports their position.
Your Honor, at the end of that, that letter from the IRS, it says the complete pointing and waterproofing. And in the case of Universal Mills, which is also cited in IRS opinion, refers to complete pointing. And in denying the portion of the MCI.
Should we take decisions from the IRS over decisions of
On-
I am still talking.
Yes, Your Honor.
Should I be taking guidance from a tax opinion on how to treat deductions as opposed to decisions by an agency with an expertise in the area that whose job it is to analyze the sections governing that body.
Absolutely, Your Honor. Absolutely, because
Really?
the IRS.
I think that was the wrong answer.
Yeah.
No, absolutely,
that's
Your Honor.
the
No.
wrong
I think the
answer.
answer was
Okay.
no.
Every day of the week, that's the wrong answer.
Right. But
The IRS gets to determine what depreciability means under IRS standards.
And
the
DHCR
rent
gets to
stabilization
decide,
law.
and DHCR gets to decide how to promulgate their own rules and what they mean.
See, the IRS determines how it's going to determine depreciation as opposed, that's under their purview.
For tax purposes.
For tax purposes. But counsel, you stated that the end of that sentence was incomplete pointing? Is that what you said?
No, it said complete.
Complete.
Complete pointing. So is that your argument, is that the pointing has to be completed?
Yes, that it has to be complete. Now, there are arguments, and Justice Nervo in his decision said, if it's 80% complete, that's considered.
And what case law supports that?
Right, so we're back to the percentage. Where is there anything in the regs or anything else that talks about what constitutes complete pointing, what percentage?
Your Honor, Justice Nervo relied upon matter, I'm sorry. He basically said, completion, he was relying upon a dictionary definition of comprehensive.
Exactly,
as
he
covering
didn't,
completely
right,
or
so
part.
I read his decision, I have his decision in front of me. He doesn't give any basis for that statement. He doesn't cite to any cases or anything else that I saw.
All right, thank you so much. You're out of time. Rebuttal.
My only rebuttal in terms of the of 201, the case that he just cited with Justice Sachs, you should know that in that case, the MCI was denied, but because they did not give any plans or diagrams to us. That is just not the case here. It's apples and oranges, and we should not deny this particular MCI because of that case.
Do you ever use regs or decisions by the IRS for your determinations as to?
We look to guidance for sure. We wanted to make sure that we did it correctly, and we used that guidance and developed our policy from then on, and that was a long time ago. We have since.
That was 91?
91. Yeah.
91.
So we've since had many orders where we either deny or we accept the MCI increase based on the expertise that we've found and figured out whether it's depreciable. And another little point that I want to make is the useful life is 15 years. They cannot come back in 5 years doing another local law 11 and ask for more time. The work, if it's done professionally, should last in the areas where they were done for 40 to 60 years, okay? You cannot ask an owner to then replace items that are completely fine or that were done in the past and are good and solid. You have to replace what was needed as inspected.
Thank you. Counsel?
Your Honor, if there are no further questions, I will rest on my brief.
Thank you so much. M. Damina versus Bodin J. You may proceed.
Thank you, Your Honors. Good afternoon, Your Honors. Andriana Toscano for.
You're going to have to bring that mic closer and keep your voice up, please.
I will, Your Honor. Good afternoon, Your Honors. Andriana Toscano for the appellant. May it please the court. There is no statute and no authoritative case which provides the counsel fees for an appeal can be awarded in a family offense matter. This case
Unless the appeal relates to one of the sections in 842, specifically 842F.
Yes, Your Honor, but Section 842F only involves counsel fees for obtaining or enforcing an active order of protection.
And is not the appeal with reference here was that not enforcing the order of protection?
No, Your Honor, it was not. Enforcing implies an act or a violation of an order of protection that is active.
Well,
Enforcing,
it also implies making the order of protection applicable, which is what your client was arguing that it was not.
correct, but it was also expired, so.
Right, but look, your client charted his own course. He filed the appeal. He brought the issue to this court and he raised it, right? Had he not appealed, then your argument would be correct because at the end it was terminated. So if no appeal, there's nothing to enforce. But your client chose to appeal, thereby opening the door again to the order that contained the order of protection.
Understood, Your Honor, but family court is a court of limited jurisdiction. If the statute actually allowed for counsel fees on an appeal, like Section 438,
We grant attorney fees on family court cases on appeals all the time.
Your Honor, it depends on the circumstance.
Exactly, it
but-
depends on the nature of the case, right?
Absolutely, Your Honor.
Okay.
But at this point, in the nature of the case, the order of protection had since expired, and the respondent had sought for counsel fees in the initial application. Those were expressly denied.
And your
Unfortunately-
client opened the door. You can't escape that. So you can argue to me that notwithstanding having opened the door, she's not entitled. I think you have stronger grounds there, but your client opened the door here.
Your Honor, understood. However, the statute does not expressly provide for for anyone to receive counsel fees in a family offense matter on an appeal. If it did, it would expressly state that, just like Section 438 does in a support proceeding. Section 438 in a support proceeding permits counsel fees at any point in time and expressly states in the statute that counsel fees can be awarded on an appeal.
The Section 842F, what limiting language is there that you believe prevents counsel fees on an appeal? Does it say not appeals?
It does not say appeals.
It doesn't just say trial fees, it says fees. So that means any fees.
But doesn't
So the issue is whether the appeal that your client filed brought back before the court the issue that the underlying orders that contained the order of protection, terminated or not, because our prior decision said on an appeal that your client filed.
840, go ahead.
Go ahead.
842 talks about obtaining and enforcing, right?
Correct.
So by the appeal, if he had been successful, and if she had not opposed the appeal, then, and he was successful, there would not be any order of protection.
There wouldn't have been one to begin with. She didn't even have to oppose the appeal, for that matter.
But she
didn't.
had a right to,
She didn't have to.
and
either
she
way.
did. Again, you said,
You're saying she didn't have to oppose the appeal?
She didn't have to. There was.
What was she supposed to do?
What would have been the benefit of opposing?
your
the-
client
the
was
benefit of
trying
appeal?
to knock out the prior order. It's not in her benefit to make sure that the underlying order stood?
The order.
Why would that not be in her interest in case he comes back and harasses her again and attempts to assault her again? So of course she had an interest in that appeal.
Your Honor, as I've stated before, the Section 842 does not actually expressly authorize it. It's not stated in.
Nor does it
If it-
expressly state that you cannot obtain attorney's fees or fees. It talks about the enforcement of it talks about enforcement. And here we're talking about enforcing the order of protection.
You'll have time on rebuttal.
Thank you, Your Honors.
You may proceed.
Thank you. May it please the court, Meryl Haft of First LLC for respondent. This is the third appeal brought by appellant against my client respondent in less than 2 years. The respondent obtained an order of protection in family court against appellant in 2023 after 3 years of litigation involving approximately 21 days of trial time and multiple motions brought throughout.
So when would the order of protection have expired?
It expired as of the date of referee Adams' decision, which was in April of 2023.
And when was the appeal?
It was perfected approximately 6 months after that. This appellate court upheld the findings of the family court, finding that the appellant had committed a family offense. On behalf of respondent, we thereafter filed a motion in family court seeking legal fees incurred by her in defending against this appeal. We made our application pursuant to Family Court Act Section 842F. This statute allows the family court to require a party to pay the counsel fees involved in obtaining or enforcing the order of the person who is protected by such order if such order is issued or enforced.
So which heading are you falling under, obtaining or enforcing under F?
Your Honor, I'm not sure, but if appellant had succeeded, if we had not opposed the appeal, as counsel suggested, do nothing, and it had been overturned, then she never would have obtained it. It would not exist. So I think the argument can be made either way. It falls under obtaining and enforcing.
So without the right to preserve the order of protection by fighting an appeal, the enforceability would be sort of an illusory benefit.
I'm not sure if it's illusory, but the idea was to maintain the finding, to enforce the finding, even though the order had expired. Judge Shim noted that the Court of Appeals has said family court has ancillary jurisdiction to carry out its core functions, and appellate courts have routinely held that an application for counsel fees incurred on appeal should be made at the trial level. In cases of statutory interpretation, we are told to look at the plain meaning of a statute. Look at the actual words themselves. The words obtaining or enforcing reasonably include appellate work in defending a finding of a family offense and an order of protection. Because, as I said before, if respondent's order of protection had been vacated, perhaps by an appeal that went unopposed, then the result would be she would never have obtained the order.
Any cases which state specifically that their counsel fees cannot be awarded under 842?
No, Your Honor, there's no case law that we found that states that counsel fees cannot be awarded under 842F.
Well, what about your friend's point that elsewhere in the Family Court Act, where the legislature wanted to authorize the recovery of attorneys' fees for appellate work, they did so expressly in the statutes, whereas here, maybe there's a bit of inferring we have to do from 842F.
Yes, Your Honor. I believe that the words chosen by the legislature themselves, obtaining and enforcing, differ from the language in the Family Court Act as to fees for support cases and in custody cases. So the words themselves, obtaining and enforcing, appear to be designed to include the defense of an appeal by the perpetrator. So I believe that's the distinction. I want to say this. Victims of domestic violence are frequently the lesser moneyed party in a relationship. They are often financially controlled, and they are manipulated in addition to being subjected to physical or emotional abuse. So here, where the higher earning party appellant has tried to undo the finding, he has engaged in additional litigation against the lesser earning party, which is the general framework for domestic violence. The more moneyed party can abuse the other party through financial means, including excessive litigation, which has gone on in this case. In his reply brief, appellant claims that because my client is an associate attorney at a law firm, she has sufficient income to pay her legal fees. What he doesn't mention, but is in the underlying record, is that he is general counsel for a subsidiary of ExxonMobil, earning substantially more than my client. Nevertheless, those are considerations for the fee hearing, which has already taken place before Judge Shim, and we are awaiting a decision. I want to close with this. There is an opportunity to say here, affirmatively, that Family Court Act 842F permits fees on an appeal if the underlying order of protection was granted and appealed by the perpetrator. This can provide guidance to family courts across the state and help victims who have been financially drained, incurring substantial debt, such as my client, paying for representation. I ask this court to affirm.
Thank you.
Matter of Lisa T. states, meaning and effect should be given to every word of a statute. Where a plain language of a statute does not address an issue, to read it in would strain the plain language of that statutory provision.
Why would such a reading strain the plain meaning of the statutory provision?
Your Honor, because
What are we reading in if it clearly encompasses enforcing an order of protection, which is what an appeal was here?
I believe that the word enforcing is, again, looking at whether or not the order of protection was violated. That is what enforcement
Well, what case law says
infers.
that?
Your Honor, it's not, well, it's not, the case law is, it's not about what case law says it is what.
In this court, it is.
Well, I understand
That's what
that.
it's all about.
Yes, that is true. That is true. But enforcing an order of protection infers, in this respect, an active order of protection. It is violating.
Well, that sounds like you're adding some words into it also. So, I mean, it's a very short one-sentence line that doesn't preclude anywhere, and no one seems to have given us any cases to preclude this request for attorney's fees, counsel fees in this situation.
And why can't it fall under the rubric of both, obtaining and enforcing, as you just heard my colleague ask?
Because at the trial level, that is what is inferred when you're obtaining an order of protection, and that is exactly what the respondent sought.
But if the appeal was granted in your client's favor on a prior case, then the respondent would have never have obtained an order of protection, right?
I'm not sure I follow. I believe that the respondent.
If your client won the appeal, right, and the court vacated the prior order, then there would be no finding of harassment due to the strangulation she alleged, and the ensuing order of protection, and the repeated orders of protection that were issued. All of that would become a nullity, as I said earlier. And if he should come back and strike this woman again, right? Now there is no history, no valid history, because it has been nullified by the appeal that you suggested her client should have ignored. That's the difference. But we have your arguments, and I hope you know this is not personal, okay? Please. All right? Some of these cases are tough. It's not personal. You're a lawyer, and we have a job to do as well, okay? Thank you
Your Honor.
so much
Thank
for
you.
your arguments.
Thank you.
Weatherspoon versus Mazal Ubracha. I hope I didn't butcher that name. Great. Ladies, thank you for joining us. Safe travels. Okay. You may proceed.
Thank you, Your Honor. Good afternoon, Your Honors. Jason Levine for the plaintiff appellant. First, we submit that the defendant failed to meet their initial burden of establishing as a matter of law that the defect on which plaintiff fell was trivial as a matter of law. The defendant submitted the photographs and the deposition testimony of the plaintiff as well as the owner.
Right, so do we have any actual measurements, or do we need any actual measurements as to whether it's 1 inch or whether it's a half an inch or whether it's somewhere in between? How do we know?
That's correct. The defendant did not submit any objective measurements by way of an expert or by way of the owner or otherwise. All we have is the estimates of the plaintiff and Mr. Badalov, the owner.
Is it necessary to have measurements or something from an expert?
I would submit under this court's case in Gogu against Gap, that's a case where the court did require an objective measurement to be submitted by the defendant, owner, and/or tenant in support of a motion for summary judgment on the trivial defect issue.
Is that especially so here where we have the difference that my colleague alluded to, one saying half an inch, which arguably under our case law would not be enough, and one witness saying more closer to an inch,
I would
which
agree.
would be enough?
I agree. I think under these circumstances, objective measurements should have been submitted, but were not, which is incumbent upon our argument that they failed to meet their initial burden.
So was relying on the eyeballing of it for measurement purposes sufficient evidence at this juncture?
We would submit it was not under these circumstances, and that's why the court should have denied the motion. Because we really have two defects here based upon what the plaintiff testified to. She testified her foot first got caught between the sidewalk and the frame of the cellar door, which she estimated was about a half inch. And then following that trip, she testified again that her foot then got caught between the adjacent cellar door frame and the cellar door itself. Which
Did
said
she
was
ever
uneven.
say how much, what the height differential was for that second fall?
She didn't judge, but the owner testified, Mr. Badalov, that he estimated that was an inch.
Because I have a picture of it, and I see those two different
Right.
falls, yeah.
So, you take that into account. If we have these two, that takes us to about 1.5 inches from the sidewalk to the cellar door, which I would submit, even if we accept those facts as true, which, under the legion of case law regarding whether a trivial defect
Well,
is a question of fact.
Certainly Hutchinson, which is Court of Appeals case from 10 years ago, suggests that those are hard issues to decide on a motion for summary judgment when we have some different testimony from different parties here.
Again, and we submit under those cases, should see on all the other cases from this court, it should have been a question of fact left to the jury to determine whether this defect was trivial or not. And it seems like, the court below, although it didn't cite it in its order, the colloquy on this case was all about trivial defect. There was no really other issue addressed. I'll briefly state that, if there's another issue here and we get past that, we would submit that the defendants didn't meet their burden regarding notice or the duty of the tenant and or owner in the situation. And alternatively, we would submit that even if we get that far, the plaintiff's expert affidavit would have raised an issue of fact. Again, I don't think we get that far just based upon the fact that there really is an issue of fact here in the first instance, whether this defect was trivial or not, and therefore the motion should have been denied. And I'll reserve my time for rebuttal.
All right.
Thank you.
It's much taller. Okay. Good afternoon, Your Honors. May it please the court. I represent the respondents in this matter. Respectfully, we are dealing with no minimum dimension test per se. What we're dealing with is a totality of circumstances. We've got the plaintiff.
Totality of circumstances. We have very clear case law about these kind of cases. And if you are going to say that the defect is trivial in nature, then you've got to establish that since you're the moving party.
Absolutely.
And since your expert says it was only half an inch, right?
No.
I don't think it was your expert.
No.
You didn't have an expert.
He had an expert that didn't give any specific measurements. I was the movant, though. I carry the burden. I agree. What I meant by totality of the circumstances is that in addition to the dimensions themselves, there are other factors that weigh into whether or not a defect is trivial. Familiarity with the area, weather conditions, possible visual obstructions, differentiation in color between the defect, the purported defect, or a non-defect. All of these things are taken into account, as are photographs, which can be considered. We've got a plaintiff who identified—
The photograph here doesn't help you.
There's a
that photograph looks like you can snag a sandal in that lifted corner of that door with no problem. In the summertime, they better fix that, or they're going to have other people tripping over that.
I believe that that photograph presented by plaintiff contains shadows that are meant to embellish the defect underneath it. I do not believe it shows—
How do shadows develop?
With the lighting and the angle.
It's called, you've got to have an angle to have that shadow.
So, well, I think they're actually down on the ground taking it. But it's this is a plaintiff who's traversed the area by her own
I'm
testimony.
hearing a whole lot of speculation.
So the plaintiff testified that it was about a half an inch, but you're the president, right? Your representative, the president, stated it was about 1 inch, right?
He estimates, and then at the end he says,
He estimates. So he estimated that it was 1 inch. She says it's a half an inch. The photograph, shadow and all, looks to be a little bit more than a half an inch. So why are there not, and it's your burden, right? So why are there not issues of fact which should go to the jury?
I believe that the photograph does not show anything.
Okay, so let's discount the photo. Let's take the photograph out. We still have we have your representative, what's his name, Baldov?
Badalov, I think.
Badalov. So Badalov says that the height difference was probably 1 inch. And again, plaintiff says that it was a half an inch.
So plaintiff twice says it's a half an inch. Badalov is not there when this occurs. The plaintiff is there when this occurs, and she describes twice what she tripped on, and twice describes.
So you want us to discount your representative's testimony, discount not consider your representative's testimony, not consider the photographs, and only consider the plaintiff who said it was about a half an inch?
No. I believe that the photograph shows a trivial defect. I believe that Mr. Badalov was saying, I don't know about, and I believe
That's not what he said. He said probably 1 inch. I'm sorry, go ahead.
No, so maybe we could just make this simple. We're supposed to view the evidence in the light most favorable to the plaintiff as the non-moving party. So maybe we could just accept the inch for the purposes of this discussion.
Well, I would accept the plaintiff's version, since the plaintiff's version has to be accepted for purposes of opposing the motion, and the plaintiff's version.
So your witness created the issue of fact.
I don't believe
your witness said one inch. Your witness created an issue of fact.
Respectfully, I would disagree based on.
So you don't. Again, his testimony was not that it was probably 1 inch, because that's what
he's speculating. The plaintiff, though, is given opportunities.
And the plaintiff isn't?
Well, she's given an opportunity.
She's not speculating? This is a little old lady who fell over this thing, right?
A woman on her third trip and fall lawsuit, yes, and she.
You know what? That gratuitous comment you could save for the jury. Okay. Not appreciated here, I gotta tell you.
She is.
Not appreciated at all.
She is a woman who is given an opportunity by her own counsel to say that it is not half an inch and repeatedly claims that it's half an inch. If we're accepting the testimony of the plaintiff's version, the plaintiff has stated that this is trivial. She has testified that she's been to this location multiple times.
She never says trivial, right? She never uses the term trivial. She says about a half an inch.
Yes, on 2 occasions, including when her counsel asked her if it could have been more than half an inch, and she says, I say half an inch.
But doesn't the administrative code 19-152 require a remediation first for defects on the sidewalk with a height differential of 1/2 inch or more, and violation of the code is one factor to consider when deciding the issue of triviality. And we know that the Court of Appeals said that that's usually an issue of fact for a jury.
Yeah, so that statute has never been alleged other than by plaintiff's expert for the first time in an expert report. And thereafter, I believe that the discrepancy is between flags and that the reference to cellar doors is a 1 inch movement when they're stepped on, which is not what's being alleged here with regard to that statute.
So I just want to say, your representative Baldoff, he says it's literally an inch probably. It's not a big deal because people usually don't walk on top of the cellars. They usually avoid it.
All right. Thank you.
Thank you.
We have time on rebuttal.
Just a couple of things real briefly. First, defendants are seeking to walk away from this photograph. The problem here is that they're the ones that
Excuse the
affirmatively
pun.
submitted this.
Walk away, excuse the pun.
Exactly. So, to say it's been
But
embellished.
again, your client does say a half an inch. And when she is repeatedly questioned about it, she says, I said it's half an inch. So.
Right, she did, but again, as I pointed out on my main argument, we really have 2 separate issues here. One is the 1/2 inch between the sidewalk and the frame than the inch that Badalov testified to between the frame and the door. She tripped twice. So
Your friend referenced the other factors other than the dimensions of the alleged defect from Trincer and Hutchinson. What's your response to those other factors that were highlighted by Hutchinson?
Right. Yeah, I think we have here, although, this took place in December at 5:45 a.m.
So
and
it's
although-
still dark.
It's still dark,
was
which
still
he
dark.
says it was still dark, but I thought there was reference in the lower court's decision stated that she could see.
She could see. She did say the lighting was quote unquote dim.
Right.
That's at page 107 of the appendix. And additionally, just vis-a-vis the plaintiff's expert, he did in fact give a measurement. It was an inch, he said. That was his finding at page 610, 611 of the appendix. And there's reference
Yes,
19.
the problem is he doesn't indicate that he actually measured with any instrument.
Right.
But we got it.
I got you. All right, thank you, Your Honor. Unless the
Thank
court has
you.
any further questions. Thank you.
People versus Hector Hernandez. You may proceed.
Good afternoon, and may it please the court. I'm Steve Moralia for appellant Hector Hernandez. I'll be brief. I'd like to just focus in on the first point that I raised, which is the weight of the evidence argument. And I wanted to just clarify that there's two aspects to the argument. The first being that this court, in weighing the evidence, has to look at the sufficiency of the evidence necessarily, and in light of the charge as given. And in this case, the evidence didn't establish the culpable mental state of recklessness. And I say that because the nature of the injury is...
Your client is trying to have his cake and eat it too. Down below, he said that it was reckless. And now on appeal, he's saying, no, this was murder, not reckless.
Your Honor, I frankly acknowledge that that is where we are, but...
Yeah, I mean, you made one argument below, and now you're making the exact opposite argument here.
And I want to clarify that my argument is that under Criminal Procedure Law 470-15-5, when an appellant, a criminal defendant appellant, invokes this court's weight of the evidence jurisdiction, the case law says the evidence has to be weighed in terms of the sufficiency is weighed based on the charge as given. So...
But I think the issue is that at trial, your client was the one who argued that a reasonable view of the evidence supported the charge of reckless manslaughter versus intentional murder.
Yes, yes. And what I'm saying now is that in independently weighing the evidence, as this court must when requested to do so, it has to look at the evidence in light of the charge as given. And although...
It doesn't make any sense. I'm sorry. I don't understand what you're talking about. What do you mean? So when he's at trial, it's intentional murder, but now on appeal, because he was acquitted of the murder and he was convicted of the reckless manslaughter, all of a sudden, no, it wasn't reckless manslaughter, it was murder?
I would take the position that, as strange as that may be...
Okay, so if we were to accept your reasoning, right, and so we would then vacate the conviction and he's free, right?
Correct.
And we have someone who was stabbed in the chest, who's dead.
Correct.
And your client goes free.
Correct.
Okay.
I just want
So what is it now? What is it that we're working with now? Well, now we're working with reckless manslaughter, right?
Yes.
Okay. And you're stating that there's no reasonable view of the evidence to support reckless manslaughter.
That was one part of the other part of my weight of the evidence argument is that assuming that the act was a reckless one, there's the issue of the identity of who was the reckless actor. And
so he's the one with the knife.
Well,
he's the one who has the kitchen knife, right? And he's the one who is face to face with the deceased, right? With the knife out, and he is the one who is seen by other individuals with the knife out, poking the deceased in the chest.
And let me be clear that
And that immediately after being poked by the knife, the victim is seen holding his chest and bleeding from his chest.
And I want to be clear that the second part of my argument is that testimony about who had the knife comes from two witnesses who I contend.
Two people said your client had the knife. One said he saw him put it in his pocket after stabbing the victim.
And the argument, though, is that neither of those witnesses is trustworthy or reliable for the reasons I go.
Well, you know what? But that ship has sailed, right? Because the jury determined that.
No, Your Honor, because under the criminal procedure.
So unless we decide that there was no conceivable way, right, that
I would disagree that we would apply.
So you have, again, he has the knife out. He pokes the deceased in the chest with the knife. The deceased then holds his chest and then ultimately falls to the ground. Your client then puts the knife in his pocket. Is the knife recovered?
No, there's no recovered knife.
He puts the knife in his pocket, but somehow there's an issue as to identity.
Yes, because my argument is that.
Did he ever argue identity when he was arguing that it wasn't intentional, that it was reckless?
Part of the summation arguments that counsel makes included that argument that the witnesses were so unreliable that we couldn't even rely on them for identifying the perpetrator of the act. So
all right,
that's
you'll have
the
time
second
on
part of
rebuttal.
that. Thank you.
Good afternoon. May it please the court. Cynthia Carlson for the Office of Darcel D. Clark. At the charge conference, defendant specifically requested a reckless manslaughter charge. The court gave that charge and the jury agreed with the defendant and convicted him of reckless manslaughter. Defendant is now trying, as Your Honor noted, to have his cake and eat it too. As this court said in Danielson, it would be an unseemly result to vacate a reckless manslaughter conviction because someone's new defense on appeal is that they intended to murder the victim. Even if this court were to ignore that defendant waived this issue and ignore that it's not preserved because he never argued.
You don't have to preserve weight of the evidence review under Danielson.
Correct. Under Danielson, you don't have to have preservation for weight of the evidence. I was referring specifically to legal sufficiency. But under weight of the evidence review, it still doesn't matter. The defendant has not raised a meritorious argument because this was, as every witness testified, a fast-paced, quickly devolving situation, a fight between gang members in the same gang, and one of those gang members was going after the defendant's friend. So there is evidence to be viewed that the defendant, in poking the victim, thought he was merely delaying an attack as opposed to actually intending to murder or cause the death of the victim. Or at least, so for that reason, the weight of the evidence corroborates the conviction.
Well, your friend on the other side talked about credibility. So there was an issue in terms of, I believe, one of the witnesses initially told the police that he had no idea who had stabbed the victim.
That's true, he did. But he also explained why he did that, and the jury heard it and credited it. And in fact, the defendant's own testimony supports the reason why he didn't come forward first. The eyewitness testified that he didn't want to tell the police. His instinct was to lie to the police because he's a gang member, and gang members do not snitch. If they do cooperate with police officers or with law enforcement, they are threatened with their life. And that is the very excuse that the defendant gave for his immediate flight to the DR the same day that he committed the murder.
Well, first he said it was a prearranged trip, and then he said no, he actually fled.
That's true. And he gave multiple statements to law enforcement, and every single statement was a lie that then at trial he completely disavowed. So the weight of the evidence here comports with the defendant's conviction. I would also note the other arguments that defense counsel raised on his brief. We stand by our arguments in our brief. The prosecutor's summation was not inappropriate, and that the defendant's sentence was valid. If there are no other questions from this court, the people request that this court affirm defendant's manslaughter conviction.
Thank you. Counsel, you have 2 minutes.
Yes, thank you. This, just wanted to clarify again that questions of preservation are not in play here because we're dealing with the weight of the evidence standard under Danielson and under the CPLR.
And does Danielson counsel us, though, that first we have to ask whether an acquittal would not have been unreasonable?
Correct.
And then if an acquittal would not have been unreasonable, then we are supposed to engage in an independent weighing. But in conducting that independent weighing, aren't we supposed to at least factor in that the jury was in a superior position to us as far as evaluating the demeanor of the witnesses?
Yes, the court will take that into consideration. That's part of the analysis. And the other part of the analysis that I was stressing or focusing on for the court, requesting the court to look at is both the reliability or lack thereof of the prosecution witnesses and the nature of the act itself.
Well, the jury was fully informed of the fact that all of these individuals were gang members, either former gang members or present gang members, and also that at least one of the witnesses had initially lied to the police and stated that he had no idea who had committed the murder, right?
Correct.
Including your client. Your client is in the same boat as the witnesses that he now points to and says they're not reliable.
That's
your client is in the same boat, and the jury heard it.
That's the nature of the case, and we just request this court to exercise its independent authority to review that under the law. Thank you very much.
Thank you. Board of Managers versus Miller. I granted the late appearing party time, please.
Arbor's recused.
And Justice Kapnick is recused on this case. Should there be a tie, the court will follow the appellate division rules and vouching in another judge. Okay. You have 4 minutes.
Thank you, Your Honor. Good afternoon, Ethan Cobry of Schwartz, Sladkus, Reich, Greenberg, Atlas for the appellant, and may it please the court. This case, or in this appeal, is not about renovations. It's about fundamental fairness and basic due process. For 2.5 years, the board and its agents stood by and watched the renovations in painstaking detail.
How is it not about the renovations when your client moved and changed structural components of the apartment?
That's disputed. We dispute that. Mr. Miller disputes that. His expert disputes that. That is far from
One of his contractors absolutely admitted that they dug a trench they weren't supposed to.
And that's true, Your Honor, in terms of the channeling, but that's not an issue on this appeal. The contractor acknowledged that he did that and that he...
And you don't think that that is an indication of that was the only thing he did that he wasn't supposed to do?
I think it would...
Counsel, come on. Channeling into concrete? That is no easy feat. And if you are prepared to do that, changing an appliance or a fixture that you don't like, that's easy compared to channeling.
Perhaps, Your Honor, but while the channeling admittedly was an issue, and it's something that the contractor actually said he did of his own volition without Mr. Miller's knowledge, but he learned the lesson from that. And I think it would be unfair, Your Honor, to penalize Mr. Miller and even the contractor on other issues.
So you're essentially arguing that there was a waiver here, right?
Yes.
Now, what evidence do we have that there was a voluntary and intentional abandonment of a known right by the condominium?
There was testimony by Mr. Miller. There was testimony affidavit.
In light of the lease contract that says there are no waivers, how do you get around that, right? Because you know the bar.
Yes.
For us to find that in light of the contractual lease language is very high. So how do you reach that?
Because, Your Honor, as this court has held so many times, I've litigated so many cases on this very point. This court holds that a no waiver provision can itself be waived. And that's what really the trial court rested.
And how did you accomplish that here? What in the record shows, as my colleague just asked?
The affidavit testimony, not only of Mr. Miller, but his contractor. And here's the point.
We're not concerned with Mr. Miller because it's not his right to waive. We're talking about acts of the condominium that show that they waived.
I'm sorry, is Your Honor asking how those could be waived?
No, how did the condominium waive these issues?
By showing up
Right, so
so
you
many
say-
times
you
and
ca-
saying
you s-
absolutely nothing for 2.5 years.
You say that they showed up, they visited and inspected. How do we establish that there was any inspection? The affidavits or the statements by the individuals in the condominium state that they went there, they visited the apartment. There's nothing that said that they actually inspected to see what was moved, what was going on.
So number one, why else would they have people inspecting the apartment if not to see what was going on and to make sure that everything
That's a
was
rhetorical
rhetorical
question,
question,
right? Because
right?
you don't get to ask us.
No,
questions.
of course it's
Okay.
I'd say of course
Right.
it's a rhetorical question, but Justice Weber, doesn't that highlight that this is the consummate factual dispute that can't be decided?
No, because why would it? Again, what have you presented to show that the condominium waived any of these issues? How did they inspect? How did they know? I mean, there
All
has to
those
be knowledge.
statements tell me is you got a bunch of nosy, busybody board members coming around. That doesn't tell me that anybody came to do an official act of inspect, et cetera. And conspicuously absent from your papers are any specifics about days, times, who, what work was going on that they should have said something about. Nothing. But you can tell us about that on rebuttal.
Good afternoon, Your Honors. Maria Boboris for Respondent. May it please the Court. I think you nailed it on the head when you said that you would have to suspend disbelief to believe that after appellant was caught channeling into concrete, that the board then proceeded to go into the apartment and frequently inspect.
Well,
and
I believe
ignored.
that, but that's not evidence, right?
You're correct.
Right?
So
So tell us what in the record establishes that there was this breach of contract such that we should sustain.
Well, the breach of contract
decision below.
is an easy one, Your Honor. Michael Zenerick laid out over 24 different breaches explicitly. In rebuttal, appellant's expert only refuted 4. Did not refute, only addressed 4, ignored over 20 other, and addressed 4 and refuted none. If you look at the affidavit, there is no citation to either.
How many of those do I need to say that this ruling is correct? Do I need to find all of the violations that were testified about were accurate to find that the breach of contract was properly reached?
Well, I mean, you would have to.
That's a friendly question.
Well,
maybe I didn't ask
well,
it
you
right.
need to find one to ascertain that there was one breach, but I maintain that all 24.
Right, I'm saying you don't need all 24 for there to be a breach.
Excuse me?
You don't need to
No, I
find
don't
all
need all
24
I need
for there.
one.
Right.
And so channeling is enough, right?
Well, he rectified the channeling, okay? He rectified the channeling, and afterwards, there were visits, and they were at the behest of Mr. Miller, who asked our clients to come in with respect to do different issues. He wanted to move a PTAC unit, which is an air conditioning unit,
Right.
in the wall, which he wouldn't have been able to get away with without our permission because it affects the facade. And then there were inspections, not inspections, visits with respect to that to ascertain whether they would permit him to do it. They would not. The second one was with respect to missing insulation around the window. Again, Your Honors, all of these times that the visits occurred, the last one was February. At that time, they were still in the demolition phase. Nothing had been built, everything had been torn down. So there was nothing to inspect, even if there was an inspection that took place.
Well, we don't have dates, right? We don't have specific dates
We have
as to.
specific dates in the testimony that I set forth
Yes.
in the moving papers as to when the visits occurred. The last one was in February.
And this is all during the demolition.
This is all during the demolition.
And there was something also in terms of the riser, the heat riser, that there was no protection around
Well, yes,
that as well?
that goes to what Lobo testified to. So our Zenerick testified that that the hot water riser was
Now
relocated.
that though was contested by the expert on the other side. I was more concerned with the fact that there were voids that were abolished and then incorporated as part of the square footage of the.
There was yes, and by the way, there was nobody that went into the apartment would be able to ascertain that. That was ascertained by an architect.
Right, so you couldn't that's not something that you could
No,
eye.
you would not know that that is a mechanical shaft that housed space that wasn't counted towards the floor area without pulling out the original plans of the building, which were submitted in evidence. There was no way to know that. And I will remind the court that the contractor confirmed that those walls were removed and weren't replaced. And Lobo says upon information and belief, all the walls that were removed were put back, which is an affront to everyone's intelligence because anyone can look at 2 pictures and ascertain that walls are still missing.
And some of these were code violations as well,
A lot
right?
of them.
Which
Most
are
of them.
not waivable.
Which are not waivable. And almost every single code violation, if it were to be rectified, would require that the rest of the non-code violations would have to be fixed as well, right? The sink was pushed into the shaft, and then the countertop is also not accessible. So it's not just code violations. They're code violations that...
Well, lack of clearance with the countertop.
The countertop, the turning radius makes it non-accessible. Also, the electrical panel was moved from where it was in the third wall downstairs to upstairs into the closet where it's now covered with clothing and shelves. And that closet has the egress out into the hallway. And the door to that closet is not code compliant. It does not provide the proper egress. It's also not handicap accessible. So we're not talking about small little, you didn't put in the right appliance. There are a plethora of code violations that
And these
Lobo did
code
not address.
violations, are these code violations, violations that the building could be fined for by the fire department, et cetera?
Of course, it's a condominium, so any violation would go, it would affect the condominium. It would affect everyone from being able to do renovations as well. But most of all, it affects the safety, right? The demising wall has been compromised. The fire stopping was not properly put in. Despite what Lobo says, she looked at pictures. You cannot ascertain that from pictures. You have to know what the specs are, which is why we submitted the affidavit testimony of the contractor to put that in. So these are not just insignificant violations. These are very big ones that affect the entire condominium, which houses 215 residential units.
Thank you.
You're welcome.
Counsel, you have a minute on rebuttal.
Thank you, Your Honor. I want to start with Your Honors, Justice Manzanet, your friendly question to my friend Ms. Baboris. Does it have to be all 24? Does it have to be any one of them?
Right.
That's one of the issues with the trial court order. The trial court order doesn't specify which of these issues, the supposed 24 issues, have been disputed properly and credibly, and which haven't been.
What about the code violations? Those wouldn't be waivable, right?
So, number one, we contest that there are code violations, as does Ms. Lobo. That's number one. Number two, the same way they can't be waived, the condominium lacks standing to pursue enforcement of them. It's one thing to say, bring in the DOB, and the DOB needs to say, there are code violations. That would be one thing. That didn't happen here. In fact, the DOB issued a letter of completion stating that everything was okay.
Yes, but that DOB of completion was done through an architect sign-off, right? Which means that nobody from DOB came and checked.
But at the end of the day, the DOB letter of completion says everything, whether they were there physically or not, whether the contractor self-certified or not.
They are relying on your client's architect.
And then they
approved
it.
That has value, but it is of limited value because it's not like I had an independent inspector come in and say, no, this was done perfect.
True.
That's not what we have here.
True. If I can just leave the court with one thought.
Go ahead.
Mr. Miller is required to destroy his home. At least let it be after a trial, after these statements and allegations are tested by the trier of fact and not on papers.
Did he do that for the building?
I'm sorry?
He didn't give that same courtesy that you are asking for your client. He didn't extend that same courtesy to the people who gave him approval and whose approval he ignored. But we will consider it.
Thank you.
Thank you. Daniello versus J.T. Megan. You have 5 minutes, sir.
Good afternoon. If it may please the court, the lower order should be reversed and summary judgment should be granted to the plaintiff. The evidence in this case, it's undisputed, it is acknowledged by the respondents on page 21 of their brief. The ladder fell over. The ladder fell over, and therefore it didn't meet its purpose of it being a proper safety device. The facts of this case, while not...
Does the ladder have to be defective under our case law?
No, it does not have to be defective. The Orland case shows that. The Orland case, which has been cited 1,452 times as of this morning, one time negatively when there actually was the scaffold pulled away by someone, which one of the ADAs here probably would see as a criminal act. Then there's no need to be a defect in the ladder. The ladder failed its purpose. The evidence here is testified by the plaintiff and undisputed that there was the tiling up above his head fell into place. He was jolted. He
was
moved
startled.
out of the way.
You know, I read it in the papers, and when I first read the brief, I thought that there was an electrical shock. But when he used the term jolted, he meant that he was startled by the fact that
he was doing
startled.
electrical work, but he wasn't electrified like some of the cases say.
Right.
He is a low voltage electrician. He had moved many, many tiles around. This one tile or two tile was oddly cut, he said, and it was a different
So
shape.
what would have been the adequate safety device under these circumstances?
Either he could have been tied off, or a scaffolding should have been there. This was a...
Would there have been enough clearance for there to be scaffolding?
Yeah, a Baker scaffold, which is,
Yeah, but I'm thinking with a Baker scaffold, would there have been enough clearance to?
Yeah, this was an office building on 770 Broadway. They have tall people than me there, so they have a good height there.
And Baker scaffolds come in different heights.
Yes.
Yeah.
So the ladder wobbled, both the plaintiff and the ladder fell over. The case law has always shown in this department that the ladder has failed its purpose here, and respectfully.
Thank you.
Good afternoon, Your Honor. May it please the court. My name is Jeremy Bernfeld. I'm an attorney for L&K Partners, a respondent here. We were the general contractor on this job. Respectfully, I will disagree with plaintiff that just because this ladder fell over, it does not mean that Labor Law 240, in fact, was violated.
Well, did it protect the worker?
It did not, but it also did not cause...
And this is a very orderly analysis in 240 sub 1, right? So was he afforded a device to protect him, and did that device adequately do its job?
The device was provided to him. It was the exact device he'd used time and time again.
That doesn't matter. Based on our case law, he could have used it all day, and if he fell at the last minute of his workday, that would be irrelevant, right? The case law says that's irrelevant.
Right, but in this scenario, plaintiffs lost his balance per his testimony multiple times, and the ladder only fell off thereafter. The ladder was caused to fall by him falling, not the other way around.
I'm sorry, he lost his balance multiple times?
No, he testified
He said
multiple
he
times.
Oh.
I apologize for the unclarity.
Yeah.
He testified multiple times that he lost his balance.
Yes, but we have a lot of cases of workers falling from ladders where they lose their balance, they slip off of a rung, all kinds of reasons. And we still find 240 sub 1 if there was nothing to protect him from that fall.
Right, but in each of those cases, there's some additional factor that led to the fall that wasn't just the plaintiff simply losing their balance. This court has recognized that if, in fact, it is just the plaintiff losing their balance, as this court found in the Mejia case in 2023, if it's just a matter of losing his balance, that's not a 240 violation. In cases such as those which plaintiff relies upon, the Lepari...
For that one Mejia citation you can give me, I can give you 5,000 citations that go the other way.
Yes, Your Honor.
And I know you know that's true because I'm sure you found them when you were doing your research.
Yes.
So we have repeatedly held the same thing. Repeatedly.
I mean, in a case from 2021 from this court, we specifically said to one of the comments that you made before, I wanted to get the quote, It is of no moment whether the ladder shook prior to plaintiff's fall or, as defendants maintain, after plaintiff lost his balance and grabbed it to steady himself. In either event, the ladder was an inadequate safety device for the work in question. So, I mean, it didn't really matter what came first or what happened first. He fell off the ladder, which he was using to do his work, meaning the ladder didn't protect him.
Right. And with all, I'm not sure which case you're referring to, Your Honor.
King Lynn, it's a 2021 case from the First Department.
Versus 100 Wall Street property.
And I apologize, I'm not familiar with that case in particular. I focused on the cases plaintiff here has relied upon. And in each of those cases, this court has indicated, for instance, in Lipari, in Lipari, that was not a case, and I'm quoting this court, where plaintiff simply lost his balance and fell from a secured ladder. Here, plaintiff set up the ladder exactly as he'd done time and again. It was secured properly. He fell anyway because
What caused him to lose his balance?
It appears from the testimony that he may have been startled by accomplishing the exact task that he set out to do, which was place his tile into the ceiling. The tile, as opposed to many of those other situations where the device that was involved, such as a loose cord, an electric cord, and shocked the plaintiff, here the tile that he was placing did exactly what he set out to do. He put it into its frame, it fell into place in the frame, and this startled him, to borrow Your Honor.
He said it was tight. You said the frame was tight and it like popped down, startling him. And that sounds to me like he had to use additional force and require both hands while atop a ladder that was not secured.
Your Honor, may I respond to that quickly?
You can. I don't know, not sure what you're responding to, but go ahead. If you want to say something, go right ahead.
Sure. Your Honor, this was above his head. It fell into place. Although it was tight, he earlier testified in his deposition that that was a normal occurrence within his work.
I haven't stopped you. Go ahead.
Oh, I apologize, Your Honor.
I did nothing. I don't know why you stopped talking. Go ahead.
Oh, I apologize for the awkward tone. No, that was a normal occurrence for him to find a tile that fit tightly into its frame, but it fit exactly into its frame as he intended, as he set out to do, as he did himself.
Okay.
Thank you.
Good afternoon, Your Honors. May it please the court. Abe Reichik from Katz and Reichik, representing the 770 Broadway, Facebook, and third-party defendants USIS and USIS Electric. I understand this court's case law and its progeny regarding that the plaintiff does not need to establish that the ladder was defective. But in this particular instance, this has nothing to do with the ladder itself. So
yes, it does.
Adequacy
yes, it does. It does have to do with the ladder. The ladder did not stay erect while he worked because it was not secured. And so it fell over, and he fell over with it.
With all due sure, Your Honor.
Counsel, you can eliminate the all due respect. We all know what that means. I don't need it. I don't require that language.
Sorry, Your Honor, but
I am not offended by you making your argument, but you don't have to say with all due respect. We know what that means. I disagree with you, Judge. Give it to me. Just give it to me.
Sure, Your Honor. What I want to do is I want to quote from the deposition testimony itself, and I think that the panel will realize that this has nothing to do with the ladder. Okay. Regarding this is plaintiff's testimony in the record, starting at 769, that when I went to put the smaller tile back, when I was wrestling around with it, then it went and fell into place. I lost a little balance, the ladder jiggled, and that's when I fell. Plaintiff continues, as I'm maneuvering the tile, when it fell into place, it suddenly fell into place. It gave me a little jolt. That's the tile, nothing to do with the ladder. That wiggled the ladder, and that's when I fell off of the ladder. He then clarified, did it give you a jolt because you were pulling the tile down? As I was getting the tile into place, the tile jumped into its spot, and then my body just jolted.
So you seem to think by reading this that we think that it's it's not that the ladder made you fall, it's that the ladder prevented you from falling. Right? So whatever it was that caused his body to move, that jolted him. The ladder did not provide safety to him.
There's nothing that the ladder could have provided. There's no adequacy of this ladder that would prevent
If
it from
someone had been
falling.
holding it, it wouldn't have
He
fallen
could have
over.
also tied it off. The testimony is that he had a tie off, and he
Was
decided
there
not
a
to use the
place
tie
to
off.
tie off?
The plaintiff decided not to tie off.
Was there a place
what?
to tie off? Was there evidence in the record that there was a place
No,
to
Your
tie
Honor.
off?
But he
Okay.
could have maneuvered. But again, there's
He
nothing.
could have tied off, but there was no place to tie off?
He could have moved the ladder to an area that could have permitted it, and he could have,
And
done
still-
the tile work differently,
Really?
Your Honors. He could have done the tile work differently.
Body of our cases, Buckley, Jones, have said that the determination of the type of safety device called for under the circumstances depends on the foreseeable hazards the worker may encounter at the elevation he or she is working at. Was it foreseeable that a worker tasked with lowering these tiles back into place might be jolted, startled, or move a little bit as a result of the shifting of those tiles?
I think that the work itself involved the moving of the tiles. An A-frame ladder was appropriate. He testified it was appropriate. It was always used for this type of task.
Well, see, that's the issue. He's on the A-frame ladder. The task involved requires him to use both hands, right? He can't just use one hand in order to get these tiles in place. He has to use both hands. So he's on the A-frame.
And
He's
they're elevated above his head.
elevated above his head on the A-frame. So there's no way for him to like steady himself or steady the ladder because of this. And that's what our case law says. We look to the task, we look to the task, we look to the device that was provided to him, right? And so an A-frame without someone holding it or without his being tied off, the task involved may cause him, and it's foreseeable that it would cause the ladder to shift and for him to fall.
But the jolting and the maneuvering of the tile, it would not matter what device was provided, whether it's
No,
scaffold
if he
or
had been
tile.
on a baker scaffold, he would have a big flat platform to work on.
It depends where
So-
if he went over. the
All right,
side,
we
it's
can
very
go back and
possible.
forth with this all
very
day,
possible.
but thank you.
Thank you, Your Honor.
You have 1 minute.
I rest my time, Your Honor.
Thank you, smart man. People versus Sergio Ceri.
Good afternoon, Your Honor.
Good afternoon.
Please the court, Richard Langone for Mr. Ceri. Your Honors, if I may, I'd like to start with point 2. I think it's pertinent. It would be a good start here. And this is with respect to Brittany's testimony, Brittany Guzman's testimony concerning, it's a text message that was offered into evidence in anticipation for a claim of recent fabrication. And the text message was a text message by someone in Mr. Celeri's family that was distributing.
Why did you say it was in anticipation? Wasn't it offered after other testimony came in to question the reliability of Brittany's testimony?
Yeah, it was before the defense case, so they were offering it in an anticipatory rebuttal.
No, it was after cross-examination, right?
Well, defense cross-examined her after the statements come in. So maybe.
So the defense cross-examined, and the cross-examination where the questions posed were leading to the conclusion that there was recent fabrication.
Well, if I may just explain to you what the text is actually saying, Your Honor, it may clarify.
We know what the text says. It's the brothers. This is the messages as to the brother, right?
This is so here's how it goes. Your
It
Honor.
doesn't really matter what the text say, right?
Right.
It matters what the text is being offered for, and that's the query that we're having with
Okay,
you.
so this, my understanding is this was offered, the prosecution's position, it was offered an anticipatory rebuttal for a defense claim that her statement to her mother in Ecuador that Sergio assaulted me, the defense claim was.
Well, I thought, and I'm sorry to interrupt you, but I thought it was offered after cross-examination wherein her credibility was challenged on a certain issue. And so it was offered to show that well, to rebut that credibility challenge.
Okay, well, I'm not sure, maybe I'm misreading the record. Let's assume that's the situation, that it was offered in response to the defense cross-examination as rebuttal. I'll take that for a second, Judge. The point of it all is the text message. So Brittany's testimony was, there was one occasion where they're in Sergio's bedroom. It's a small bedroom, it's a railroad flat apartment. The bedroom is right next to the kitchen where the mother is. The door is always open, and these events go on there. Brittany testifies to 2 incidents where she was sexually touched by Sergio. One of those incidents, the first one, he pulls his pants down, but he still has his underwear on, and he supposedly rubs up against her. And his penis rubs up against her, according to the testimony. She's asked, did you see it? Did you look down? Well, I didn't really look. I tried to look ahead. I didn't really want to look at it. Okay. So I want you to, there's a little ambiguity in what she actually saw. So just freeze that for 1 second. Now here's the text. Listen to the text. This is...
She has to see it for there to be enough evidence for a conviction?
No.
I'm trying to understand what your point is.
So it relates to the text. If I get to the text,
let's get to it.
I'm trying. Okay, so Brittany asks Karen if she sees the photo. Karen said, I don't want to see this. Brittany says, is it really that small? Looking at the photo. Now, what is she referring to? What's in the photo, or is it referring to Mariano, or is it referring to Sergio? Karen, so Brittany's saying, is it really that small? As if, I don't know how big it is. Right? Is it really that small? If she's talking about Sergio, she's saying, is it really that small? If
Well, she's not talking about Sergio. She's talking about the brother, okay?
Okay, so then she's thinking
let's
and
stop
the
dancing
picture of his
around.
penis.
And
What are we talking about
We
here?
know it's the picture of the brother's penis.
Right,
I'm still not understanding.
Okay, so let me
And then within the text message, she makes reference to the fact that your client's penis is small. Move on.
Exactly.
Move on from that.
But here is where it's at, though, because no, it's bigger than his older brother. This is what Karen is telling Brittany. No, it's bigger than his older brother. But I feel bad for Sergio. No wonder he has no girlfriend. That thing. Now, it's insolubly ambiguous as to whether they're referring to what she knows about Sergio, or she's referring to...
She's comparing the brother to the defendant.
So what that thing is...
The penis.
Yeah, I understand that, but...
Right, we all understand, so I don't...
So what is the point? Again, this was based upon the cross-examination by the defense attorney to show that this was recently fabricated. And by these text messages, it showed that it wasn't recently fabricated.
Well, Your Honor, my interpretation of the text message is that it's ambiguous when you put it together with the girl's testimony, with Brittany's testimony about what she actually saw.
Okay, fine, but this was before the jury. It went before the jury. The jury made a determination, and even if you state that the judge should not have allowed these text messages in order to refute recent fabrication, there still was overwhelming evidence as to the defendant's guilt.
Well,
which I guess you'll get to on rebuttal.
Yeah.
You'll have time on rebuttal.
Time's up, thank you.
Spend too much time on the penis.
You may proceed.
Good afternoon, and may it please the court, Catherine Mariah for the people. I will briefly address point 2 about text messages. On cross-examination of Brittany, defense counsel was trying to create the inference that Brittany was making up this story in order to prevent her mother from beating her with a broomstick. So on cross-examination, defense counsel was creating the inference that she had only made up that story at the moment in Ecuador. However, these text messages between Brittany and Karen show that Brittany had seen defendant's penis 3 months before this disclosure ever occurred. So,
right, but again, the photos were of the brother's penis.
The photo was of defendant's brother's penis, but the two girls had an exchange comparing the brother's penis to defendant's and showing that Brittany had already seen defendant's penis. So that exchange was admitted to rebut the fabrication.
As a prior consistent
As a prior
statement.
consistent statement of Brittany's to rebut the fabrication that defense counsel was trying to allude to.
Did anyone ask at trial to redact that portion of the text thread that depicted the picture of the penis?
To redact the thread.
Just the picture of the penis itself, not the colloquy that occurred back, the chain, whatever the kids call it, between the two girls, but the offensive image, if you will.
No, there was no discussion about any redaction. There was a back and forth about defense counsel objecting to it being admitted, but there was, and as Your Honor said, even if there was, there's harmless error here anyway, because there was overwhelming evidence. I'll get to that point. The people's proof of defendant's guilt was sufficient, and the jury's verdict comported with the weight of that evidence. Here, the two young victims credibly testified in front of defendant at trial about the abuse they suffered at the hands of defendant, and the jury was able to evaluate their demeanor and evaluate their testimony, and I think deference should be accorded to that. Also, the girl's testimony was consistent with other evidence at trial, including the text message exchange between Brittany and Karen, and also testimony by Karen's family members, her mother and her sisters, about the change in her demeanor over the 2 years of the abuse. And
There's a psychologist who testified.
there was a child sex abuse expert who testified, kind of providing context for the girl's testimonies, saying that there could be a delay in disclosure because the abuser is usually someone who's known to the victim. Here it was Karen's cousin, and Brittany was Karen's best friend. And yes, so there's just no innocent explanation for defendant's behavior here. He would go uninvited to the victim's bedroom and start by tickling her and moving her hand up her leg to her inner thigh to her vagina, and this occurred over 10 to 20 times over the course of 2 years. Then he escalated his behavior to a second victim, to Brittany, touching her vagina on 2 occasions. I can address the sentence point if you want, but
Sure,
okay.
You have time.
So yes, defendant's sentence of 12 years incarceration is fair and appropriate. Here there was 2 victims, so the consecutive element is appropriate. As I just said, defendant began his abuse with his 10-year-old cousin, and then escalated that to her best friend 2 years later. There's an element of grooming and luring these girls.
How old was he at the time?
He was 26 in 2019 when it started.
What's your response to your friend's point that there was a meaningful disparity between the sentence that was meted out after trial and the pre-trial offer and the offer before the case went to the jury?
So I think in that case, I think defense counsel kind of mischaracterizes the record a little bit. The people wanted to spare the girls from testifying. So it's not so much that the defendant was punished after trial, but we were trying to give a benefit pre-trial to spare these girls from testifying, but he rejected those plea offers. And I just want to kind of correct the record a little bit. The first offer was a 5 or 6 year offer on 2 Class D felonies, which didn't include the rape or the attempted rape counts at all, and defendant rejected that. And then the girls testified. And the last plea offer was 8 years to the attempted rape or the course of sexual conduct, which he also rejected. But just the mere fact that there's a 4-year difference between the 8-year offer and the 12 years which he originally got does not mean that that's a trial tax or that he's being punished.
Thank you.
Thank you.
You have 2 minutes.
Thank you, sir.
Sir, what was the prejudicial impact or effect of the admission of those texts?
Well, the credibility here was the essential issue in the case. The jury deliberated for 2 days, so the evidence was not overwhelming in my mind, and multiple rereadings of testimony and et cetera, and evidence. So they were thinking about it. The 10 to 20 times, the first time she testified to that, Karen, was at the trial. She never mentioned it before. In fact, there was an argument about it. The defense counsel said, wait, I'm being sandbagged here. Nobody's ever mentioned 10 to 20 times to me before. She never told the police, never told the grand jury. Listen, Dr. Meltzer testified at the trial that up to 25% of the allegations of sexual abuse by children statistically are untrue. Now, we all know how children have wild imaginations.
I thought she said that it was very uncommon for children to make this up.
It was uncommon?
Yes, I thought she said it was uncommon.
Well, she was giving a presentation, I think, the following day on the subject of what causes children to make false allegations. And the point of this is going to our facts here is I've had a few of these in the past, and it seems it's easy for kids to get stuck in a story. You had a child here who might have been raped at 7 years old.
She stated it was not common for children to fabricate abuse allegations.
You got to read the whole,
Abusers often desensitize children by tickling them or gaining their trust by buying them gifts.
Yeah.
Abused children find it embarrassing to discuss sexual acts that have occurred. I'm sorry, what were you saying?
Yes. There's more. She's testified to more than that. I believe it's in my brief.
You were saying something about your vast experience in handling these cases.
Well, vast, I've had some. I'm not going to say I'm so, but whatever. Here's the point of it. This child may have been raped as a little girl by her stepfather.
And that was not in the record, and I believe that there was a statement that it should not have been stated, right? There was no basis for that?
My understanding is it is in the record. The jury heard it, and I don't believe it was strict.
Okay, go ahead.
Okay? Because it's a very important issue. It should be in the record, in fact.
The jury heard it, they considered it. What do we, if you're saying, right, that the jury heard it,
yes,
they considered it, what do we need to know about it?
What I'm trying to do is present the case here, Your Honor. I'm trying to talk about the possibility that the evidence is not overwhelming, that under the weight of the evidence of review, okay, that you can look at the facts and make your own interpretation and act as a second jury in a sense.
Of course, that's what we're clearly doing based on your appeal.
Yes.
Okay?
And my point of it is that the child was watching adult pornography at the age of 12. She was very sensitized to sexuality as a young child. Her mother was obsessed with it because her mother said she had been sexually abused as a child, and she had a great distrust of boys. She didn't want boys around her around her daughter. So Brittany testifies that she was talking to Karen, teaching Karen.
All right, we're out of time, but we have your brief, and I assure you, sir, we go through everything.
Yes, Your Honor, the child was steeped in paranoia. The kids were stuck in their story.
Thank you.
And they couldn't get out of it. Thank you.
Thank you. People versus Damian Bell. You may proceed.
Good afternoon, Your Honor. May it please the court. Whitney Elliott of the Legal Aid Society for Damian Bell. Damian Bell never registered in New Jersey.
Why is that?
Because he was not going to reside, work, or study in New Jersey.
I thought also because he had to come to New York on another case.
That's correct.
Okay, so he didn't register in New Jersey, and so your argument is because he never registered in New Jersey, although he was supposed to register in New Jersey, that therefore he should not register in New York?
No, that is not my argument, Your Honor. And its critical argument is that he was never supposed to register in New Jersey.
Well, if he was going to remain in New Jersey, he'd have to register.
Yes, because there's an additional requirement.
But he wasn't going to remain in New Jersey, so that's why he didn't register in New Jersey. But if he were to remain in New Jersey, he should have registered there, and then therefore he would have to register in New York. Right.
If he lived, worked, or studied in New Jersey, he would have been required to.
But the reason that he did not remain in New Jersey was not of his own volition. It was because he had a case here.
Fair. The reason that he didn't remain, with respect, Your Honor, doesn't matter. The statute.
Of course it does, because if he had remained, he would have had to register in New Jersey.
Correct, but the New York statute, the foreign registration statute, talks about whether the person is required to register in the convicting jurisdiction.
And he was required to register in New Jersey.
No, he was not, Your Honor. I just want to emphasize, under New Jersey law, a conviction of a sex offense.
So you're basically arguing that a person convicted of a sex crime in another jurisdiction where the statute says if you don't stay here, you don't have to register. All they have to do is move and come to us.
Exactly.
And they don't have to
And then,
register
so
here.
they can-
That's your argument?
So they can totally evade registration and evade the statute by simply moving to another jurisdiction.
Is that your argument? Because you want us to say, sure, come over here. You don't have to register here. You convicted sex offender over there. That's what you want us to hold?
No, Your Honor, and this is an absolutely critical point, because right next to the foreign registration provision clause is the essential elements clause. And that clause allows the prosecution and the court to look at all of the relevant conduct. It's not just the elements, all of the facts underlying the conviction, and decide whether it matches up to a New York registrable offense. And anytime any person is convicted of an offense in another jurisdiction, the essential elements provision is available. And under that provision, under matter of North, the court gets to look at all of the underlying facts. But the prosecution waived reliance on that here and failed to preserve it. And so all we're saying, and so for all of those cases where someone is not required to register in another jurisdiction, the prosecution will have, as they had here, a full and fair opportunity to apply and argue for the essential elements provision. They didn't do that here. They waived that argument here. This is just like People versus Kennedy, the Court of Appeals case, where the prosecution, there was a military conviction for an indecent assault, and the prosecution waived reliance on the essential elements provision. And that's just a critical, I think, misrepresentation about the consequences of our argument here. The reason we're here on this foreign registration clause is because essentially the prosecutor dropped the ball. They had the essential elements clause available to them, and they waived it, Your Honor.
So what I don't understand from your papers and the basis for this appeal, in your papers you state that it is his intent to go back to New Jersey.
Well, at the time, he
So,
wasn't.
so if he's going to go back to New Jersey, I don't understand what the issue is. Because once he goes back to New Jersey, will he not have to register?
If he returns to New Jersey.
And you state in your papers that he wants to go back to New Jersey.
That was the argument below, Your Honor. At the time, it wasn't back in 20.
I thought I saw in the papers that he wants to go back to New Jersey.
That was the argument in 2019 at the hearing.
He no longer wants to go back to New Jersey. He wants to stay here in New York.
Correct, Your Honor. I mean, and again,
So he wants to stay here in New York, but he doesn't want to register.
he doesn't have to. He doesn't have to register because he was never required to register. I just want to make this about New Jersey law. A conviction of a sex offense in New Jersey is a necessary but not sufficient condition for a requirement to register there.
But there are two factors, right? There's also the factor in terms of if he had registered in New Jersey, which we know he did not do, and also whether it's a registrable offense in New Jersey, right? And so you're saying that the people did not pursue registrable offense in New Jersey, and so therefore they cannot pursue the fact that he did not register in New Jersey, but should have registered in New Jersey?
I just want to try to be clear about this, and if I was unclear, I apologize. So there are basically two ways, as relevant here, two ways that a conviction in another state can result in a duty to register. One is the essential elements provision. If the conviction in the other jurisdiction, for example.
Right, so there, like you said, there are two ways. Either you have to register in the other state, or the elements meet elements here for a crime for which you'd have to register.
Right, and you stated that the elements are not met here, so therefore he would not have to register based upon the elements. He was convicted of criminal sexual conduct in the 4th degree, right?
Criminal sexual contact, yes, Your Honor.
Contact in the 4th degree. So you're stating that the elements of that crime do not meet the requirements for registration here in New York.
No, I'm saying that under the essential elements clause, although it's called the essential elements clause, under matter of North, the court can look at all of the underlying conduct there. I'm saying the prosecution waived that argument where they could have looked at all the underlying.
Okay, so now the only thing that you're stating that we're left with is the fact that he should have registered in New Jersey, didn't register in New Jersey because he came to New York.
No, he should not have registered in New Jersey, Your Honor.
If he were going to stay in New Jersey, he would have had to register.
Correct. And the foreign registration clause talks about whether been convicted of an offense for which the individual, quote, is required to register.
So we should not look to the fact that the only reason he did not register in New Jersey was because he came here to New York. He had to come to New York on the other case.
So
He was in custody.
I don't
Correct?
think any of that matters.
Counsel, I understand your argument, but let us get our questions out, because what you think matters may not be what we think matters.
Fair enough.
Okay? So, go ahead, keep going, because I just got my,
Judge Michael.
I lost my train of thought.
Justice Michael?
Just because he didn't register in New Jersey, and the only reason he didn't register in New Jersey is because not of his own volition he was transferred here, that means that we should not look at having him register here in New York?
So
He would have been required to register in New Jersey, correct? Had he stayed in New Jersey, he would have been required to register in New Jersey.
If he had no hold that transferred him here after his time was done on the case, he would have had to register.
Well, not necessarily. If he was going to live in New Jersey, he would.
So if he was staying in New Jersey, he would have had to register in New Jersey.
Yes.
Right?
And so you're saying that we should disregard the fact that the only reason that he did not register in New Jersey because of residency was because he had a hold here in New York and then was brought to New York.
No, it's not just because he had a hold there, Your Honor. Under New Jersey, the New York statute talks about whether the person, quote, is required to register. And under New Jersey law, you are only required to register if you have been convicted of a sex offense.
Which he was.
Which he was, but that is a necessary but not sufficient condition for a requirement to register.
Right.
And the other conditions were not satisfied, whether it's because...
And the other condition is what?
That he live in New Jersey.
That he live in New Jersey.
Correct.
Or work in New Jersey.
Right.
Reside, work, or study, Your Honor. And because he didn't do any of those things, he was not required to register as a result of his conviction in New Jersey.
Okay.
That is our point.
I got your argument.
Your Honors, and may it please the Court, Anna Notchik for the people. Defendant was properly required to register as a sex offender in New York based on his New Jersey conviction, which was for a registrable offense in New Jersey. Under the New Jersey registration...
You're saying, because we went around a lot with your colleague, that because, he says that because he technically was not required to register in New Jersey, he might have, having been convicted, but because he wasn't going to live, study, or work in New Jersey, he wasn't required under New Jersey law to register there. Therefore, the prerequisite for him having to register in New York was missing. He was saying that was missing. And it didn't really matter if he chose voluntarily, or he had a hold, or he decided to move to someplace else. It didn't matter. That's his point. So that's not what the statute says?
No, two points there. First, the statute under subsection A1 of the New Jersey registration statute, it says that an individual convicted of a sex offense shall register. And then it says that they shall register as provided by the procedures in subsection C and D. But I just want to be clear that just given his conviction, he had to register in New Jersey.
Well, see, that's what I wasn't clear about, because I thought I saw an argument made that the people did not pursue the registration based upon his conviction in New Jersey.
So so we did, I think, erroneously concede the essential elements position below. However, what we did argue was that he was required to register in New York because his conviction in New Jersey was for a registrable offense in New Jersey. It's under a different subsection of correction.
Right, but that would only flow from his working or residing or going to school, what have you, in New Jersey, right?
I disagree with that. I think that he was required to register before he ever left New Jersey. That he didn't isn't part of the analysis here. It's whether he was ever required to, not whether he actually did register.
But is that what you argued?
I think that, Your Honor, I don't think that's actually what we argued below, because I do think this whole argument is unpreserved. Never once below did defense counsel ever mention a residency requirement or that he wasn't required to register because he wasn't going to reside there. That was never discussed below. I do just want to say that we did argue below that this was for a registrable offense in New Jersey, and
So
that's
you saying his argument is unpreserved?
yes, Your Honor.
Okay.
I just do want to say we did argue below that his conviction was for a registrable offense in New Jersey, and that is conceded on appeal. This was a conviction for a registrable offense in New Jersey, even if we accept that there is.
So the crux is not that he in fact registered, but that it was registerable.
Exactly, Your Honor. And even if there was some residency requirement, that he was moved to New York doesn't, or he should still be required to register in New York. I know we discussed a little bit the policy considerations of this, and by opposing counsel's argument, defendant can simply remain in New York and avoid registration in both New Jersey and New York simply by living in New York.
But if that's what the statute says, then that's what the statute says, and our distaste for its outcome doesn't allow us to apply it in a way not intended.
Your Honor, I want to be clear that we think the statute does support our position. I just did want to know the policy.
But you wait. I'm trying to understand that position, because you're saying it's registrable because it was a sex offense, right? A qualifying sex offense. But the other criteria there is that he reside in New Jersey. Is that not what the statute says?
I don't think that's what the statute says, Your Honor. Subsection A1 says that an individual shall register as provided in subsection C and D. Subsection C specifically says that an incarcerated individual must register prior to release from incarceration. There is no clause there that the individual must only register if he is going to be released into New Jersey. It says he must register prior to release from incarceration. And I think that shows here that defendant should have registered. Docs probably didn't, or New Jersey docs probably didn't have him registered because he was being sent to New York and was going to have to register in New York.
And what does the relevant New York corrections law provision provide here?
The correction law provides that when someone is convicted of a felony that requires registration in the state of conviction, they must register upon relocation to New York.
So it goes back to he was required to register, whether or not in fact he registered for whatever reason, good or bad, it's that he was required to register under the sister state law.
Exactly. That he did not actually register is not part of that. It's whether he was ever required to, and I think it's very clear that this was a registrable offense that would require his registration.
Thank you.
Thank you.
Counsel, can you address that specific argument just raised by your adversary?
So in terms of whether he was required to register in New Jersey. So yes, and I want to be very clear about this. And so the operative provision is 2C section 2C colon 7-C2, and that's the provision that addresses when an individual who is incarcerated and is about to go in the community into the community must register. But that provision does not say any sex offender or any person convicted of a sex offense. The term it uses, which is a term of art under New Jersey's Megan's Law, is a, quote, person required to register. And just last year, in matter of JR, New Jersey's Appellate Division said that term of art, person required to register, does not encompass a non-New Jersey resident, even one who has been convicted of a New Jersey sex offense.
Well, is he a non-New Jersey resident?
Mr. Bell was. He wasn't going to reside in New Jersey.
No. At the time that he was arrested and convicted and sent to jail, was he a New Jersey resident when he was put in jail for this crime?
I'm not sure. That's not in the record.
Ah.
No.
What a surprising answer.
But no, Your Honor, what matters is where he's living at the time he goes into the community. And that's
no, I think what matters is whether he was required to register as he was in New Jersey corrections. And from what your adversary said,
he was. If you have to register before you are released, then it cannot possibly be where you intend to go live, right? It has to be where what your residence was when you entered.
No, no, Your Honor. The duty to register in New Jersey, and there's a New Jersey Supreme Court case that we cite in our reply brief, talks about the duty to register commences upon release into the community, and the term of art that the statute uses is person required to register, and the New Jersey appellate courts have authoritatively construed that term to mean that it does not cover a non-New Jersey resident.
So somebody who's in jail, who lived in New Jersey, committed their crime in New Jersey, got convicted and sent to jail in New Jersey, at the point that they're about to leave, are we not entitled to consider them a New Jersey citizen? Resident? No?
If they're going to be released outside of New Jersey, then they are not required to register in New Jersey.
That wasn't my question. That's not what I asked you. But it's okay, because you're never going to answer it anyway. Thank you. One Riverrun acquisition versus Simon Mildy. I think we're gonna run over because you guys heeded my request for low argument time too much, but go ahead.
I'm happy to get the court out of here early if possible.
All right, go ahead.
Good afternoon, Your Honors, and may it please the court. Jed Bergman, Glenn Ager, Bergman, and Fuentes on behalf of appellant and counterclaim plaintiff, Greenwich Group International, or GGI. Your Honors, I'd like to focus on 4 key grounds for reversing the Supreme Court's decision, starting with successor liability, and in particular, the fraudulent transfer exception under Schumacher. This exception was satisfied here. In fact, the Supreme Court found that GGI validly stated a claim for fraudulent transfer. But despite that, when it came to successor liability, the Supreme Court dismissed our claim because it found there were no, quote, independent allegations other than those supporting the fraudulent conveyance claim. That was error. Schumacher doesn't require independent allegations above and beyond a fraudulent transfer. That's just not the law. And respondents don't even defend that part of the Supreme Court's ruling on this appeal. So the bottom line is that under Schumacher, the same fraudulent transfer allegations that the Supreme Court already sustained also state a claim for successor liability, and the court erred in dismissing it. Second, the exculpatory provision. The Supreme Court held that that provision bars GGI's intentional tort claims against the individual ORA defendants. That was error for 2 reasons. First, the exculpatory clause by its own terms doesn't cover tort claims. It's on page 275 of the record. It's 2 sentences long. The first sentence says, no individual person shall have any personal liability for any performance required herein. Any performance required herein, contract liability. That's the first sentence. ORA relies on the second sentence, and the words they focus on are the words that say no personal liability, which they say means of any kind. But ORA skips over the words that link the 2 sentences, which are critical. Those words say, without limiting the generality of the foregoing. Those words exist, they have a well-settled meaning. It means including but not limited to. It means these are some examples. The second sentence does not broaden the first. The second reason the clause doesn't bar our claims is because our claims are for intentional torts. Tortious interference, intentional fraudulent transfer, and fraud. Under well-settled New York law, it's not possible to exculpate someone for an intentional wrongdoing. That's what was alleged here, and the Supreme Court's decision on the exculpatory clause should be reversed as well. The third error is the Supreme Court's finding in its supplemental order at page 820 of the record that the property transfer to ORA Keystone was, quote, contemplated by the letter agreement. That's just wrong, and the court conflated 2 totally different things.
Didn't the letter agreement require notice to GGI before ORA transferred the property to anybody after they entered into the letter agreement?
The letter agreement required not just notice, it gave GGI
consent.
and ORA decision-making rights on major decisions, which transferring the property certainly is.
Yeah, that was that kind of the big thing was the
Yes,
property, right?
It's kind of
The
hard to
thing.
tell
The thing.
The thing, yeah.
It is the thing. It required GGI's consent. That was not sought. The whole thing was done in secret. The other kind of telling point that this was not the transfer contemplated by the agreement is the agreement contemplates a transfer to a yet-to-be-formed new entity.
And am I right?
That
No
would,
new.
that would be run by both
Run by both
entities
together. Yes.
But, no, that's okay. But am I right that there was no, I mean, the name of the company wasn't going to be Newco. They were just using that, like, you have to get a new company. Let's call it Newco. But no Newco was ever created, right? Or did they ever?
At the time of the transfer, Newco had not yet been created. The transfer didn't go to the new entity that was now called Newco that would have a real name. It went to Aura Keystone, owned by all of the same Aura people.
Right. But did they ever create this new company?
Well, what happened afterwards is that the venture fell apart. We allege that Aura forced us out. And so ultimately, the entity that would be jointly controlled by Aura and GGI was not created.
That's what I'm asking you. So that was never created. So because they had that chart in the papers, and it seems like that never happened.
That never happened, and the rest of the dispute is about why. Just final point, very briefly, the fourth error, the Supreme Court's reliance on extrinsic evidence, in particular, the Kirsten Canada affirmation, which was submitted after oral argument, and which in any event under this
Those
court,
2 days where he wanted a short briefing, additional briefing?
Correct. There was normal briefing, oral argument, supplemental briefing. With the supplemental briefing, the Canada affirmation was submitted, well settled under this court's rules that affirmations are not 3211A1 documentary evidence. The court improperly relied on it and should be reversed.
Thank you.
Reserved for rebuttal. Thank you.
May it please the court, Lauren Saboxblatt from Brown Rudnick on behalf of the respondents. So starting with the exculpatory clause, counsel claims that this limiting provision limits the liability or the exculpation for all the individuals to just contract claims. But as your honors are very well familiar with, you have to...
What language in there goes beyond contract claims?
It says there shall be no personal liability on the part of the principals and employees of either party, period, full stop.
And how about the first part of the sentence?
So, Your Honor, if you...
What about the first part of the sentence? Don't read me half of a sentence.
No, I agree. I understand that it says without limiting the foregoing, but it also says that there should be no liability, period, full stop. And if you read the so basic principles of contract construction...
So we've never held that a person can be exculpated from liability in doing something that smacks of intentional wrongdoing.
Well, in both Centro, which is a Court of Appeals decision, as well as this court in the LMM Cap Partners case, they have held that releases can extend to fraud as so long as there's no separate fraud, which is not alleged here. And so here, basic principles of contract construction holds that you need to read that, first of all, that non-parties to a contract cannot be liable for a contract. So without any exculpation here, there would be no liability for the individuals that are non-parties and did not sign the contract. So what are the parties agreeing to? They're agreeing to something beyond a contract in this last sentence because they wouldn't have been liable under the contract anyway. And so we have to, as this court has recognized hundreds of times, give meaning to every sentence in that agreement and read that second sentence to mean something different. When you look at the cases that GGI cites, when it's talking about all these, the public policy.
Doesn't the provision have to have some language that would evince an intent to release from fraud? And what language is that in the provision here?
There's no holding that it requires that. It just requires that in this language, it's incredibly broad. It doesn't in any way limit it to any types of claims or in any way exclude any intentional torts from this. It covers everything.
But the release would have to have language that would evince an intent by the parties to release even claims of fraud.
My reading of the cases that I cited to you is that so long as there is a broad enough exculpation that covers those claims, the parties can agree to that. What's prohibited under public policy is to eliminate liability for any wrongdoing, for any intentional tort. Here, this exculpation clause, as written, doesn't eliminate a fraud or an intentional tort claim against the entity Aura. In fact, the trial court sustained that claim here. So this wouldn't violate public policy if you interpret it in the way that I described. But in any event, even if you don't agree with the trial court with respect to the reading of the exculpation clause, respectfully, the trial court was still correct, and I'm just going to go through the reasons really quickly. With respect to the fraudulent transfer claim, The trial court in sustaining the claim against Aura Keystone relied on a March assumption of liability agreement. And I'm going to just tell you, the discussion begins at E55. And specifically, the court said that there was an assumption of liability to Aura Keystone in March after the dispute between the parties arose. In this case, the only allegation of wrongdoing to the individuals in connection with the transfer was in December of 2021, within weeks of the signing of the agreement. So even if you accept their standard that you don't need wrongful intent, which I think everyone could agree is not pled here other than a conclusory statement that there was no liability for the individuals to evade in December 2021, within weeks of this agreement. The parties were in their honeymoon stage. Everything was great. With respect to Aura Keystone, there was different evidence in the record that the trial court relied on.
Well, wait a second. You're saying everything was great, but it seemed to me that not terribly long after the agreement was signed, I don't know if it's 5 weeks, 6 weeks, there was a transfer that ultimately ended up with this property going to the individuals. So I don't see what kind of honeymoon period that is. Maybe they didn't know about it initially.
That's why it was a honeymoon.
You know, maybe that's why it was. But then when they found out, it wasn't so good. So I'm some kind of missing something in what you're saying.
So thank you for raising that. So when Your Honor referenced before that the property is the whole thing, actually, if you take a close look at the letter agreement doesn't say anything about the property.
The entire purpose of this joint venture was to build a ski resort. Where were they going to do it? On the top of their head?
Your Honor.
Your client was the one bringing the property to the table, counsel.
And they were bringing
So
Yeah.
what are we talking about here? If you don't have property, you don't have a ski resort.
What our client was bringing to the table was the $15.3 million in cash equity that was specifically referenced.
We didn't even start on that, since all of that was an actual cash that your clients lied about. But we have your papers on that issue.
Thank you.
Very briefly, Your Honors. I heard no answer to what the words without limiting the generality of the foregoing mean. Those obviously link the two sentences. If you look at what's referenced in the second sentence, it's kinds of persons. The first sentence lists a whole bunch of kinds of persons, but it all just has to do with liability for the performance required herein. Second, Centro is a release case. It's not an exculpation clause case. There are obviously different considerations when you're settling a dispute and when you're going into a contract and saying, I can do whatever I want. You're not allowed to exculpate intentional wrongdoing, and that's not permitted here. It is not the case that the only allegations of wrongdoing are in December. The complaint itself alleges extensive allegations of wrongdoing through and including April and May 2021. And the distinction between Aura Keystone and the individuals and saying there was bad blood with one but not the other just isn't tenable, because it was the individuals who were running the entity. So for the reasons articulated this afternoon in our briefs, we ask that the Supreme Court's decision be reversed. Thank you.
Thank you. Olympic Galleria Company versus SIT.
We're the closers.
Well, we have one more to argue. I don't know where they are, but.
I don't think they answered.
No,
No,
they
that's
didn't.
it.
You're it.
That's it? Okay, all right.
I represent defendant, appellant respondent Jackie Sitt. For the ease of reference, I'll just refer to my client as the appellant. I'll refer to the plaintiff, respondent, appellant as the respondent.
Okay.
Unfortunately, I have to start with 2 bits of housekeeping. First, as you know, there's a cross appeal here, and despite this court's explicit rule, respondent refuses to reimburse appellant for 1/2 of the cost preparing the record. It should be ordered to do so. Second, point 1 of respondent's reply brief in further support of the cross appeal should be stricken, as it does not address the cross appeal, but is in fact an impermissible surreply in response to appellant's appeal. Now, I'll move to the merits. We contend that in this ejectment action, respondent was required to give predicate notice of 6 months to terminate appellant's month-to-month tenancy. And because it gave predicate notice of only 90 days, its ejectment claims should be dismissed. The motion court held that Real property law 232A was applicable here, and that statute only requires 90 days
Now,
notice.
obviously, you don't agree with that.
Yes, Your Honor.
So why do we go back to the common law for this?
Okay, three reasons, Your Honor. We have three legs to our stool. First of all, look at the text of 232A. The notice that it requires a landlord to give requires the landlord to say that if the tenant does not remove himself or herself, quote, the landlord will commence summary proceedings under the statute to remove such tenant therefrom.
So you're saying this would only relate to a summary proceeding in civil court, which I think there was one, but that kind of got discontinued.
Yes.
But it would not relate to an ejectment action such as this.
An ejectment action in Supreme Court.
Right.
Yes, that's
I
exactly right,
meant
Your
it,
Honor.
yes, in Supreme Court.
Second, as cited in our brief, multiple courts have recognized that Section 232A does not apply to actions for ejectment of month-to-month tenants and have held that in such circumstances, the landlord is required to give the tenant a 6-month notice of termination of his or her tenancy as required by common law.
Well, if I may play devil's advocate,
Sure.
some courts have held to the contrary.
Well, I think it's undeniable that the most comprehensive explication of this issue is set forth in the Casa v. Legg case.
I agree with you, that's comprehensive. The one asterisk I would put next to that decision is, and maybe you'll say it's not material, it's pre-HISTPA.
Yes, I will get to that. And also, cases also Paz Rentals and North Flats LLC. Both of those cases were post-2019. Okay. Also, in this case, I don't think the respondent has cited any case that is held to the contrary. Cites a bunch of cases, but it's all dicta in all of those cases. Third, settled rules of statutory construction support our position. It is well settled that a statute will not be deemed to have supplanted a common law rule unless the legislature has expressed a clear intent to deviate from the common law, and such intent should be found within the words of the statute.
May I throw one back at you?
Sure.
There's another rule of statutory construction that I'm sure you're familiar with that says we don't interpret a statute that would produce, in a way that would produce an absurd result. Would it be absurd to apply the timing of the notice to summary proceedings, but not to ejectment actions?
Well, when the statute expressly refers to summary proceedings, I think you have to interpret it as applying to summary proceedings. If you interpret it otherwise, this would require a landlord to serve a notice that actually says something that's false, because it requires the landlord to say, I'm going to be commencing a summary proceeding if you don't move out. But if it's an ejectment action, Supreme Court, that's exactly what they're not doing. So that's the absurd result if you apply that statute to such an action on a month-to-month tenancy in Supreme Court.
You have anything else, Judge Aguirre?
No, thank you.
Okay.
And what I would also say is, with regard to the 2019 amendments, again, there's nothing anywhere in that statute that says anything about supplanting the common law. Furthermore, if you look at the text of Real Property Law 226.c, it doesn't seem to address month-to-month tenancies at all. The text speaks of a landlord either offering to renew a tenancy or the landlord not intending to renew a tenancy, which sounds like tenancies for definite terms, not tenancies for indefinite terms like a month-to-month tenancy.
Now, interesting, in Senator Stuart Cousins' memo in support of HISTPA generally, but as it relates to these provisions we've been talking about, she says Sections 6 and 7 of HISTPA conform existing notice requirements for month-to-month tenancies to the notice requirement created by Section 3. She's talking about month-to-month tenancies broadly, not just those confined to summary proceedings.
But the legislature already has a statute about in tenancies in New York City. Remember, they expressly carved that out.
You'll have time on rebuttal.
Thank you, Your Honor.
And I'm going to give you an extra minute since he had one, okay?
I'll make it brief, Your Honor. First of all, I think everyone received the change of circumstance notice I sent to the court a couple of weeks ago, informing them that Judge Frank, the court below, granted re-argument.
And he granted part of.
So the only issue that I seek to raise on appeal is the failure to award prejudgment interest. And it's pretty clear under his factual finding that the tenant wrongfully withheld the rent, we should be entitled to prejudgment interest. It's a basic rule that where somebody's withholding money that the plaintiff's entitled to, the plaintiff should get prejudgment interest. I think that's all that I need to say on that. In terms of the statute, I think Counselor has really got it all wrong. The statute doesn't say that the landlords are limited to only summary proceedings. It simply says what language must be contained in the notice. And 232A specifically references 226C. Both of these sections were new as of 2019. And Section 29 of Part M, which created these new sections.
Your adversary's argument was that 232A doesn't apply.
It absolutely applies, Your Honor, because 232 says that the notice that must be served is the notice required under 226C. And the notice under 226C says where, as here, the tenant has been in possession for 2 or more years, a 90-day notice is what is required.
So are you, to sort of follow up with Judge Higgitt's question to your colleague, you would think that it would be an absurd result to come out one way in terms of notice for a summary proceeding, and a different way for an ejectment, which all kind of ends up with getting the tenant out of the premises, rather than the absurd result that he
Not only do I agree with Your Honor, but if you turn to record page 211, Appellant's counsel himself stated in connection with the second case that was dismissed, quote, plaintiff wrongfully served a 30-day notice to terminate instead of a 90-day notice to terminate as required by Real Property Law 226C and Real Property Law 232A. That's from their memorandum of law. So I argued, one of the points I argued was judicial estoppel. If you take a position in the prior case that a 90-day notice was required, and then in the third case, we serve exactly what they said, how do you somehow claim otherwise? The whole theory of judicial estoppel is that a party is stopped from adopting a different position in a subsequent litigation between the same parties, especially when that position was taken to get that second case dismissed. There's no reasonable interpretation of 226C or 232A which lends support to their position, and I've cited 4 cases right on point that do an excellent analysis. They're
But sir,
cited
what
on
about
pages.
what about the language in 232A that the express reference to a summary proceeding?
That's a good question, Your Honor. The language only specifies what must be stated in the notice. It doesn't in any way limit a landlord's remedies. It doesn't say that the only remedy shall be a summary proceeding. It says that the language in the notice must state that the landlord, and in this case, the notice stated that the landlord will either commence an action at law or a summary proceeding. So we covered both bases of the notice here. And it's also important to understand how that whole 6-month notice came about. It came about as a result of an 1806 decision where at the time, a tenant who stayed over the term of the lease could be held to a new term for an entire year.
It was year to year.
Right, exactly. And the majority in that 1806 decision said that's just not fair. You have to give a tenant 6 months' notice. And that's where that notion came from.
So here with a month-to-month tenancy, a 6-month notice doesn't seem to have that same effect.
A 6 months notice would be appropriate in a year-to-year tenancy, but certainly not in a month-to-month tenancy.
Do you agree with your friend that this is a month-to-month tenancy? We all seem to be operating on that with that premise, and that the common law rule was for month-to-month tenancies 6 months, but that HISTPA has, well, the statutory scheme, whether it was pre or post HISTPA, has displaced that.
I don't necessarily agree that that was the law. That was certainly a view expressed by the Brooklyn Supreme Court in the decisions that have been referenced. But regardless, HISPA definitely dispensed with that. They said that you've got to serve a 90-day, and that's all that's required. And the cases that do a full analysis seem to agree, notwithstanding the two anomalous Brooklyn cases that appellant is relying on. Thank you, Your Honors.
I have, I think, 4 points.
I hope one of them is judicial estoppel.
What?
I hope one of them is judicial estoppel.
Sure. I'd love to raise judicial estoppel. First, never an issue raised below by the respondent. Second of all, the reason why the 90-day notice was sufficient in that second summary proceeding commenced by the respondent was because it was a summary proceeding where the statute specifically says you're supposed to have that 90-day notice applies. This is not a summary proceeding. Second of all, counsel has garbled the relationship between 226 and 232. After the 2019 amendments, the only thing that was imported into Section 232 were time periods. It did not expand the actions that were subject to 232. So for actions that were covered by 232, i.e. summary proceedings, those were the time periods. But it did not affect actions, it did not expand actions that were subject to
232A doesn't make reference to 226-C1, which has that broad language about whenever a landlord
exactly just imports the time period.
References to subdivision 2, which lays out the various timing requirements.
Just imports the time periods. Third, if there are all these cases that disagree with our cases, I'd like to see them on the notice issue because,
so
as I said, we have all sorts of dicta, but no holdings. Finally, the respondent really skipped over their cross appeal. I just want to say a couple of words about it. The motion court applied the controlling rulings of this court. The respondent is not entitled to award of prejudgment interest on any recovery here. Respondent's counsel said, oh, it's clear from the record that the appellant wrongfully withheld rent. Well, it's absolutely not what the motion court found. It's clear that the appellant twice tendered the rent to the respondent, and the respondent rejected it. If you look at pages 17 and 21 of the record,
Because that would have started up the tenancy again, which was a problem for fire.
I'll get to that.
Okay.
If you look at pages 17 and 21 of the record, the respondent is practically patting itself on the back for its vigilance in rejecting the appellant's payments. Justice Kaplan, could you remind me again? I know I have a response to your point. I'm sorry. Oh, yes. Remember, in the three cases by this court, Sandar, BN Realty Associates, and W54-7, for 30 years, this court has set forth a procedure. If you want to accept the rent without jeopardizing your case, just get a court order. And nowhere in the record is there any explanation as to why the respondent didn't do that. I have nothing else.
Thank you.
Thank you, Your Honors.
Oh, right here is across the field.
Thank you, Your Honor. Briefly,
Give us-
page 7 of the record states what the lower court actually held. And with respect to the tender, the court specifically found that the tender was only made twice during the window periods. It was not made any other time. This is not the same, I'm reading from the decision, as ready and willing and able to tender payment as they became due. The court therefore found no tribal issue of fact as a waiver, and summary judgment was granted in favor of the plaintiff. Landlord's not required to delay its proceeding to seek use and occupancy. And the idea that by not doing it, we shouldn't get the prejudgment interest is absurd. And last, with respect to your question, Your Honor, there is a part of section 226.1 that says it applies in a case or the landlord does not intend to renew the tenancy. So we were required to serve a notice under 226C1. Thank you, Your Honor.
Thank you.
Thank you.